idea is that they'll build up from the ground. You are the same issues in English language.
Paul, you're very generous. Thank you.
Can I submit a question to you?
Yes. I just won't know the answer. Good morning. My name is Michael Hunter Schwartz, and I am the Dean of McGeorge School of Law. I'm actually the 10th Dean of the Law School over our 100 years, and I'll continue to be the Dean for 4 months, 1 week, 1 day, and 15 hours or so. I want to welcome you to McGeorge for those of you who are not students or alumni, let you know how thrilled we are to have you here, and how passionate we are about the subject of today's symposium. I want to particularly thank our law review leaders for today's extraordinary plans, the speakers. It was a lot of work. I want to start by thanking the editor-in-chief, Kara Anderson, who I think may be the most communicative editor-in-chief in the history of the journal. Well, maybe just with me, I don't know. I want to also thank Articles and Symposium editor Tae Kim, who handled the lion's share of this work. I think it's okay if we applaud. So when you're thinking, oh my God, I've never seen a better symposium, you need to sort of gently look over and say, oh, this is why. I want to thank the members of the Law Review Board for their help, in particular, Griff Ryan Roberts, Sonny Gorba, Khalil Ferguson, Joshua Interiano, and Zach Byrne. You can thank them as well. For a number of us, Moises Gonzalez, a member of the incoming Volume 57 Board of Editors, gave you your name tag and program, so we want to thank him for his help working the event. And certainly we want to thank the McGeorge staff, faculty, administration for their teamwork and support in planning this event, particularly Associate Dean Prosky, Professor Mike Vitiello, Ashley Gollage, Judy Wynn, Chris Gimroth, Monica Alarcon, Monica Lopez, Patsy Gray, Angelica Maldonado, and Anne Franco. You can thank all of them. In short, it was very much so a group effort. We got just in time for you to hear me thank you, so good timing. Our symposium issues of the Law Review will be publishing this spring, Part 1 in early April, Part 2 in May. We encourage all participants to read the articles themselves when they are released, as the talks are really previews of what the authors have to share with us. I want to take a moment and contextualize this symposium in the context of McGeorge being a law school where hard conversations happen, because that's such a core part of our ethic, and so I want to make sure that I share that. One of the things I think we're very proud of as an institution is that we as a community crafted community standards for civil disagreement. They were drafted by our students. They were approved by our faculty and our Student Bar Association, so that we had a context for having hard conversations, because the reality of the law is that it's lots of stories of humans treating each other like crap. And so there is pain to hearing the violence of human behavior that is embedded inherently in the law. And so I'm particularly proud of our students and our community that we've been able to navigate that. And to give you just two quick examples that sort of foreshadow today's symposium, last spring, we brought together our community for a session entitled Against Hate and For Speech, bringing together people talking about the very painful conflict in Palestine-Israel and all the challenges and pain of that particular conflict, and had a very candid, not completely without frustration and strong feelings, but nevertheless had the conversation that I think is what a law school should be doing. Then just a week ago, we had a speaker that was regarded as particularly controversial because of statements he had made about the conflict in Palestine-Israel. And again, very successful event. And I really do credit our extraordinary students for that. I do want to also take a moment and share with you that it is not a random thing that McGeorge is hosting a conference about victims' rights. It is completely consistent with the long history of McGeorge. We have a long history of supporting crime victims and their rights. We established our first Victims of Crime Clinic in 1977 and expanded its impact in 1984 by establishing the California Victims Resource Center, a one-of-a-kind center dedicated to providing education, legal advocacy, and critical resources to victims, their families, and service providers. And to that end, we actually have in the room the very first director of the McGeorge Victims Clinic, Glenn Fay, over there, for those of you who don't know that. And the immediately prior director of the program, Miriam Elman-Shawi. She's now become very fancy, and so she's now like an appointed person by the governor. So I think she'll still talk to many of us now that she's fancy. But she is a McGeorge alumna as well, and we're very, very proud of her incredibly impressive work. So today, McGeorge is one of the few law schools to offer a victims' rights course in criminal procedure, ensuring that the next generation of lawyers is equipped to champion justice for those in need. It is a course that, I guess in this context, I would call her Professor Elman-Shawi, has taught for us many times, and brilliantly so, and to the delight of our students. Finally, I have two last things. One is at the very conclusion of today's symposium, we will have a reception to celebrate the 40th anniversary of the California Victims Resource Center. So please join us for that. There will be refreshments and food, and so I really encourage you to do so. And then I'm going to actually do something that almost no humans actually ever do with a program, which is look at it. And when you look at it, at the very back, you will see a QR code. And is it the last page or is it the back? It's the, yeah, so it's an inside cover. And that QR code is a mechanism for you to share your questions with the speakers. So we want to encourage you to use it and to engage in the conversation that we are trying to have here today. And with that, I just want to thank you again for being here. Completely thrilled that you are, and completely excited by the incredible lineup of speakers, and I'll say even including Mike Vitiello.
Good morning, everyone. I'm Professor Andrew Jers. I'm the Robert Eglett Evidence Chair and a Professor of Law here at the University of the Pacific McGeorge School of Law. It's my great pleasure to have the opportunity to introduce our keynote speaker today. This keynote speaker today is Paul Cassell. He is the Ronald N. Boyce Presidential Scholar and a distinguished university professor at the University of Utah S.J. Quinney School of Law. He has an enormous wealth of experience, far too much for me to be able to cover in a brief period of time. So I just wanted to spend a few moments talking about some of the highlights, particularly in regards to today's subject matter of victims' rights. After Stanford Law, Paul clerked for Judge Antonin Scalia at the time of the D.C. Circuit, and then for the Chief Justice of the United States, Warren Burger. He served in the Justice Department of the United States and also in the U.S. Attorney's Office for the Eastern District of Virginia. But by 1992, he had joined the faculty of the University of Utah and remains there to this day. He's a leading scholar of criminal justice issues and an advocate for crime victims' rights. He was once confirmed as a U.S. District Court judge and decided that he wanted to return to academia years later to continue his work on behalf of crime victims. He teaches crime victims' rights. He teaches criminal law and other similar courses at the University of Utah, and is an author of a textbook on victims' rights, along with several of our other panelists who are here today. Today, he's delivering our keynote address regarding the history and the importance of the victims' rights movement in the United States. Please join me in welcoming Paul Cassell.
Perfect, thank you. Well, thanks for that kind introduction, and I want to start with a couple of thanks. First to Mike Vitiello for setting up this symposium. We had a chance to chat a little bit last night, and I'm not convinced yet that he's 100% on board with the victims' rights movement's agenda. But of course, he hasn't heard my remarks yet, so I hope springs eternal there. I also see some of the editors from the University of Pacific Law Review. I want to thank them very much for, I think they invited me to write a little symposium contribution, 10 pages, 20, 50, what about 70, would 140 pages and 954 footnotes be all right with you all? And they very graciously said yes. I think they told me they were up to about footnote 863 right now and are marching through those. So thank you very much to the editors for allowing me to go on at some length. Obviously, there's so much to be said about the victims' rights movement and how important it's been and so forth that it took a little while for me to get through all of that. In fact, let me sort of start diving into the talk. Let me give you an overview of my talk today. I'm going to start by trying to describe how the crime victims' rights movement is one of the most successful civil liberty movements of all time. And of course, in this day and age, I know some institutions are no longer fact-checking, but I know this group will probably want to fact-check what I say carefully. So let's see what the source is here. Oh, it's from the McGeorge Law Review, so it must be very well, or I'm sorry, it's at the University of Pacific Law Review now, but the predecessor institution. So obviously a very high-quality conclusion reached by John Gillis and Doug Ballou, two friends of mine. And then let's take a look at what we want to be talking about in light of the program today. I'm going to be talking about the movement's past. I think when we look at crime victims' rights, we learn very quickly that this is not some newfangled modern invention, but actually has deep roots in American history, particularly the history of private prosecution. And then if we go to the movement's present, or modern ascendancy, I guess as I'll describe it, we see that from, I don't know, the mid-70s and thereabouts, over the last 50 years or so, the crime victims' rights movement here in America has succeeded in placing into criminal justice processes the rights for victims to participate. And I'll illustrate that. There are probably a dozen or so rights we could talk about, but I'll illustrate that with the right to deliver a victim impact statement at sentencing, an area that I know Professor Vitiello and I have discussed in the past. In fact, we had a debate here, I think remotely or something, on the topic of victim impact statements, where Meg and I think tried to double team him. He did the vote counting at the end. He claimed that the votes came out in his favor. I don't know, we're still wondering about that, but we can continue some of those thoughts today. And then we'll talk about the movement's future a little bit, try to set an agenda, describe the agenda that the victims' rights movement has, maybe an agenda for today's symposium as well. And through all of my presentation today, I'm sure you'll see, can you everybody read this? This is the subliminal message that I'll be delivering. Maybe I should highlight for you. My subtext today, or message that I'll try to convey along with these other 3 points, is that the victims' rights movement is not about lock them up, how many years can we put someone in prison and so forth, but it's about a participatory right for a victim to have a voice in the process, which might, let's be candid, in some cases ask for a longer sentence than the judge is prepared to deliver, but it might also be a case where the victim is asking for a less punitive sentence or restitution or other kinds of conditions that may or may not be punitive. So I'll try to convince you today, and perhaps some of the other panelists, that this is an important feature of the modern victims' rights movement. So let's get started. How long did I have, Andrew? Do I have 6 hours? Is that what you said? No, I'll try to make sure that there's a little bit of time for questions at the end, and then, of course, we'll dive into the other panelists. So let me begin now with the crime victims' rights movement's past, going back to the start, the birth of the nation in 1789 up through about the 1970s. And you'll see that we go from a time of private prosecution to, by the time we get to 1976, a very famous phrase, the crime victim is the forgotten man or forgotten person. So what did our history look like at the time of the birth of the nation? A lot of our criminal justice structures were imported from England. That was a system where there was not a public prosecutor. You're familiar with the district attorneys around the state of California and elsewhere that handle prosecution as a public matter today. But that's not the way the country looked in, for example, 1789 when the Constitution was initially drafted. Private individuals, victims of crime, for example, would initiate criminal prosecutions. They would be perhaps assisted by maybe a constable or someone in apprehending the suspected criminal, but after that it would be up to the victim to move forward with the criminal proceedings, handling the case, perhaps hiring an attorney to assist with that. There might be the aid of public officials along the way, but this was very much a victim-driven system if we go back that far in history. Now, at some point, and here I'm going to summarize, I have about 40 pages in my article that try to march through the different historical periods. We could spend a lot of time on that, but I'm today going to try to move quickly to the more modern times. But you see that certainly at the time the Constitution was drafted, there was this history of private prosecution. It continued. I have a section in the article that talks about Philadelphia, And even in the 1860s, 1870s in Philadelphia, you see private citizens are driving much of the criminal system. They're the ones initiating charges, pursuing charges, and so forth. Now, eventually, though, at some point, for reasons that are still somewhat debated, we moved to a system of public prosecution where, for example, here in California, you have district attorneys for the various counties who would be handling criminal cases. Perhaps this was because victims didn't have the energy or the knowledge or the resources to initiate criminal prosecutions. Maybe there was a public interest involved that crime victims were not effectively serving. But for whatever reason, we've moved away from a system of private prosecution to a modern-day system of public prosecution. But even so, and here's just a little passage from my article that'll sort of summarize where we are. Even if sitting here in 2024 or 2025, private prosecution remains legal in 7 states listed there, and that's defining private prosecution as a system where non-governmental parties can initiate and pursue their own criminal cases. If you expand that definition slightly to say, well, could victims assist by maybe having a family prosecutor assist another public prosecutor, you see a large number of states, 20 or so. This is, by the way, according to Professor Kaufman's article in the Cornell Law Review. So you can see, even in America today, there are ways in which private individuals, crime victims, can pursue what are often described as public prosecutions. It'd be interesting to hear from some of our other speakers who are, I think many of them teach criminal law. The conventional story told in criminal law is it's a public system of public prosecutors and crime victims maybe get to show up briefly at the trial, but other than that, the conventional story is victims have very little to do. I think that conventional story is at war with 200 years of American history, as I try to outline in my article. Well, so that's sort of brings us through very rapidly the crime victims' rights movement's past. Now let's go to the present of the crime victims' rights movement, what I call the modern ascendancy of the movement, starting from sometime in the 1970s through to today. And I think one of the important events in the crime victims' rights movement, or at least a marker in the movement, was the 1976 article by William MacDonald, who, writing in 1976 at a time of the bicentennial, said the victim is seen at best as the forgotten man, we would say the forgotten person now of the system, and at worst as being twice victimized, the second time by the very system to which he is turned for justice. If you were to go into American courtrooms, criminal courtrooms in 1976, you would have found very little role being played by, a very limited role being played by victims. MacDonald describes, yes, they show up briefly to testify at the trial, and after that they're ushered out of the courtroom, really have little to do in the process, the forgotten person then in the system. So let's look at the trajectory of the movement from 1976 through today. The movement's birth is generally attributed to the confluence of 5 developments, and you can see those listed there. Again, my source for this is Marlene Young and her husband John Stein. Marlene was the executive director and the creator, I think, of the National Organization for Victim Assistance. There are a couple of organizations that are very prominent in the history of the movement, and I think if we're trying to figure out what is the movement, how did it come to be, what is the agenda of the movement, we would be looking to those national organizations such as NOVA, the National Center for Victims of Crime. The next speaker in our program is going to be Meg Garvin, the executive director of the National Crime Victim Law Institute. So those, I think, are the kinds of organizations that constitute the core of the movement. Of course, when you talk about a crime victims' rights movement, you can find examples and illustrations of a variety of things. I think Professor Vitiello has done that in his book, sometimes, in my view, sort of finding more isolated examples of what might or might not be part of the victims' rights movement. But here, I think, is the general description that most people in the movement would adhere to as to what started the movement rolling forward. And here's an example. We've already heard from your dean about the role, for example, that McGeorge Law School played in the early part of the victims' rights movement. We go from 1976, where the victim is the forgotten person, and now people start to think about the victim, such as Glenn Fate, who helped to start the clinic here at McGeorge, expanding it in 1984, and so forth. So if you're wondering, what does the movement look like? What is happening at the birth of the movement? Some people say, oh, it was all about locking them up and restoring the death penalty. I think that kind of a conception really doesn't do justice, for example, to the Victims of Crime Assistance Program, which had nothing to do with, for example, the death penalty or mandatory minimum sentencing and so forth, and yet there it is at the birth of the movement, trying to provide assistance to the forgotten person of the criminal justice system. If you're interested in greater detail on this, Miriam El-Mashawi has an excellent article also appearing in the symposium that tries to work through the history of the Victims of Crime Assistance Program, and then later the California Victims Resource Center. Well, here's another important date in the history of the crime victims' rights movement. 1982, the president had appointed a task force on the victims of crime with diverse membership on the task force. They got together, held hearings around the country, put together about a 100-page report that had dozens and dozens of recommendations for how to improve the plight of the victim in the criminal justice system. And it's very interesting, I was working on my article, going back and looking at that 1982 report with its list of rights that needed to be included in the system. Many of them now I think we would almost take for granted, but they were innovations in 1982 when the task force put together its report recommending an expansion of victims' rights in the criminal justice system. And since then, this is now flashing forward, I guess, from 1982 through today. The green states are the 36 states in the United States that have victims' rights in their state constitutional amendments. All 50 states also have statutory schemes that provide victims' rights in various ways as well. So if you were to go into, I don't know, Wyoming or Arkansas, you would find victims' rights, but they wouldn't be in the state constitution. California, very famously, has adopted 2 constitutional amendments protecting crime victims' rights, and I'll talk about those a little more. These amendments, I think it's fair to say, stem from the 1982 report of the President's Task Force on Victims of Crime. And it's interesting now as we're going to get into this debate about, well, what is the victims' rights movement? You know, how does it work? One thing that I want to put on the table, and I talk about this in my article, is what I'll call the Carrington Rule. As the victims' rights movement was starting to pass these amendments, what should go into the amendments? Well, the key institutional players in the victims' rights movement followed an informal understanding of what the movement's agenda was. This was sometimes referred to as the Carrington Rule because Frank Carrington, who was here in California, first proposed the idea. The basic idea was that, look, if we're going to have a crime victims' rights movement, there needs to be a shared understanding of what we're trying to do. And there are going to be people who think, for example, that the Miranda rules go too far, or that the exclusionary rule is unfair for searching for truth in the courtroom, to sort of describe quote-unquote conservative positions. Or there may be those who say that we need gun control to protect victims of gun violence, or we need a national system of health care to make sure that crime victims have their psychological and medical needs addressed. Let me be clear, all 4 of those, I think, policy proposals that I just described might be good ideas. They might be bad ideas, but under the Carrington Rule, they would not be agenda items for the crime victims' rights movement. Individual participants in the movement were certainly free to step forward and argue for any of those kinds of things. But under the Carrington Rule, the key institutional players for the movement says, let's focus on things that involve procedural rights for victims of crime, giving a voice to victims. And then once victims have that voice, they can argue for a longer sentence or a shorter sentence. They can argue for restitution or a condition of release rather than prison. Or maybe they can argue for a longer prison term. Or they could give a victim impact statement in a death penalty case. All of those things were part of the movement because those were things involving the victim's voice. but it wasn't about the ultimate outcome in the case. The victims' rights movement has triumphed because he got 7 years in prison instead of 2 years. That was never the point of the victims' rights movement, at least the institutional movement. And I describe that at greater length in my article. Well, so in light of the Carrington Rule, let's take a look at a few of those amendments that I just put up on the map of the United States. And what you see, for example, is that in 1988, Florida, one of the first movement, first constitutional amendments protecting crime victims' rights, not very long, right? What you're seeing here is what, essentially a single sentence extending to victims in Florida 3 rights: the right to be informed, here's what's happening in your case, the right to be present, you can go into the courtroom and watch those proceedings, and to be heard, for example, to deliver a victim impact statement at sentencing at all crucial stages of the criminal justice proceedings, to the extent those rights do not interfere with the rights of the accused. So Florida had essentially a single sentence victims' rights amendment. The trajectory, to sort of tell you where we're going to end up here, is you'll see much more elaborate and extensive constitutional amendments. So for example, here in your home state, California, in 2008, California adopted what sometimes referred to as a Marsy's Law Amendment, but you can see there are 16 specific rights: right to be treated with fairness, right to notice and to reasonably confer with the prosecutor, right to deliver a victim impact statement, right to have the notice of these items 16 there, right to be informed of the various rights that victims have throughout the process. In fact, it was kind of interesting when I was putting the article together. I went back and found, some of you may have heard of Kamala Harris, who was the California Attorney General and in charge of, obviously, criminal justice issues to some degree here in California. So here is the Marsy's Law card that then Attorney General Harris put together, available in multiple languages and so forth, that is handed out. If you're a victim of crime in California today, when the police agencies are responding, you'll receive something like that, giving you the notice of the various rights that exist. And also, there's a back page oftentimes on these kinds of Marsy's Law cards where victims can obtain services, counseling services, or other things like that might respond to the victimization. Here's another more recent example. Meg Garvin and I have written an article about this particular amendment, just using it as a prototypical example of the modern crime victims' rights movement. And here you can see, I've excerpted this just a little bit, but you can see again a list of, 16 or so different kinds of rights. Let's see, the first one here, the right to due process and to be treated with fairness and respect for the victim's dignity, the right to be free from intimidation, harassment, and abuse, reasonable protection, right to be heard, deliver a victim impact statement, and so forth. So this is, I think, when you're talking about what is the victims' rights movement doing today, I think this is a prototypical example of what the rights are. Now let me drill in specifically then to one right. Obviously, I don't have time to talk about all 16 rights today, but let's look at one. And again, Professor Vitiello and I have debated this before. Should there be a crime victim's right to be heard? So let's talk about that a little bit. Again, if we go back, where did the sort of birth of this idea come from, at least in American criminal justice? I know we're going to have some distinguished speakers from Italy and elsewhere today who are specialists in comparative law, but so I'll be focusing on American crime victims' rights, which I think we can trace back oftentimes to the 1982 President's Task Force on Victims of Crime. Here is the relevant part of the report on that. Victims, no less than defendants, are entitled to have their views considered. A judge cannot evaluate the seriousness of a defendant's conduct without knowing how the crime has burdened the victim. So the point is, before a defendant is sentenced, he has an opportunity to stand before the judge, to allocute is the phrase that is used. The defendant's counsel has the right to do that. The task force recommended that a victim also have the right to do that, along with the state's representative, the prosecutor, and provide a victim impact statement. And so if you look at the trajectory of what I'll call VIS, or victim impact statements, there were about 8 states that allowed victim impact statements in 1981. President's Task Force report comes out in 1982, moves to 39 states allowing it in 1986. All 50 states had done so by 1999, and the federal system as well. We are going to have a few comparative scholars speaking today, so sometimes people say, oh, the American Victims' Rights Movement, that was just, those prosecutors were very effective in lobbying in America. I think the challenge I would throw out to those who try to advance such a story is, well, it's not just America that has victim impact statements. You can read the long list of countries that, in one form or another, obviously there are variations in criminal justice procedures from nation to nation, but if you want to look for someone, look at other countries, do they provide an opportunity for the victim to pass along information to the sentencing authority? You'll see that exists in a wide range of places, including, interestingly enough, the Rome Statute of the International Criminal Court, which has had some interesting proceedings where that right has been exercised. Initially, our U.S. Supreme Court declined to allow victim impact statements in capital cases. There was never a serious constitutional question about non-capital cases, but in death penalty cases, in Booth versus Maryland, the Supreme Court said this was unconstitutional. It was, I guess, a violation of the Eighth Amendment's prohibition of cruel and unusual punishment. 4 years later, however, the Supreme Court reversed its position on this. And one of the things that's interesting, if we're thinking about the victims' rights movement, here's an example of a Supreme Court justice mentioning the movement, criticizing the earlier ipse dixit from Booth, that a crime's unanticipated consequences must be deemed irrelevant to the sentence. That conflicts, argued Justice Scalia, with a public sense of justice keen enough to have found voice in a nationwide victims' rights movement, an example of the movement beginning to influence even our U.S. Supreme Court. Now, there are those who would criticize victim impact statements. For example, writing in this symposium, Professor Vitiello suggests that victim impact statements skew the imposition of the death penalty along racial lines, and he'll obviously be speaking in another hour or so, so you can hear him develop that argument at greater length. Let me just offer a couple of initial thoughts. I don't tend to agree with him on this point, and after hearing my bullet points, I'm hoping he'll change his views, but if not, you'll have a chance to hear what he says about that. First, it is important when you hear Professor Vitiello speaking on this, he concedes he cannot prove this point, but he does argue that there is support for this in the so-called Baldus study. The issue I have with that assertion is that I think the Baldus study is irrelevant to victim impact statement issues. The Baldus study collected data from the state of Georgia in 1973 to 1978 on death penalties, and then did some statistical analysis on whether race of the victim was creating a situation where racial considerations were dictating outcomes. But the problem is Georgia didn't allow victim impact statements until about 1992, so the Baldus statement doesn't have any data at all on victim impact statements. Now, perhaps Professor Vitiello will say, well, wait a minute, the study does show kind of a race of the victim effect, and so then we can by inference say that maybe the victim impact statements were going to somehow exacerbate that. But there's another problem with that, which is that the Baldus study has been, I think, fair to say, refuted by Professors Greiner and Rubin, among others. Greiner is the head of a empirical studies project at Harvard Law School. Rubin, a very distinguished professor, peer-reviewed journals, and so forth, that have shown that the statistical methods that Baldus used are invalid for the reasons that I set out on the slide. Now, Professor Vitiello in his article says, well, look, most law professors think the Baldus study is good, but it's interesting, to my knowledge, no law professor has responded to the Greiner and Rubin study saying that the study used invalid statistical methods, which is pretty well accepted in the statistical community. So I'll be interested to hear what the thought is on that. And finally, the last point is we do have statistical evidence on whether there's a effect on sentencing from victim impact statements in the non-capital context, which is millions and millions and millions of cases. The number of death sentences in America is, at most a dozen or two every year. So if you're looking at system-wide impact, we ought to be looking at data from victim impact submissions being made in millions of cases around the country. There's no link to harsher prison sentences. Interestingly, there isn't statistical proof on this point, but there are hints statistically that a victim impact statement may increase the likelihood of a judge awarding restitution, a point which makes some sense if the judge is hearing directly from the victim who may be providing information about consequences of a crime that might well lead to, might well lead to additional restitution. But there is no statistical evidence that shows that victim impact statements are leading to harsher sentences, which then by definition would mean that they can't be leading to harsher sentences based on race or other impermissible factors. So in any event, I think that the critics of victim impact statements have a lot of work to do to demonstrate that all 50 states, the federal system, dozens of other countries are making a mistake in allowing the victim's voice to be heard at sentencing hearings. But let me make one other argument as to why victim impact statements should be viewed as appropriate, or two other arguments actually. Let me talk about the legal acceptance of victim impact statements. This is an interesting point. We have something in America, and those of you who've had criminal law have learned about the model penal code, which has been described as, quote, a remarkable effort to professionalize criminal law. Again, we always want to check our sources here, so let's see who said that. That's Professor Vitiello in his excellent book on the crime victims' rights movement. Would this be the right time? Available at bookstores everywhere. Quite a good book. Actually, I'm serious. I call it a very readable book. You know, obviously, we have slightly different views on some of the topics, but it is really quite a read that I encourage you to take a look at. But the point is, I think, you know, we can all agree that the model penal code is really a remarkable effort, and it describes, I think, a lot of a modern American criminal law. And what's interesting is that today, in 2025, the model penal code provides an opportunity for a victim to provide a victim impact statement in writing before sentencing and an oral victim impact statement at reasonable length at the sentencing hearing itself. So if you're trying to figure out where should I be on victim impact statements, are those, you know, just some cockamamie scheme that victims' rights advocates have come up with, it's now something that's recognized in the model penal code, a remarkable effort to professionalize criminal law. And here the model penal code reporters explain why. They've put that in. They talk about the ascendancy of the crime victim as being one of the most important developments in American criminal justice in the late 20th century. It is true that initially when the model penal code was drafted in the 1960s, that there was no provision for victim impact statements, but that times have changed is what the model penal code reporters say, and nowadays there are countervailing attention and prospective claims of crime victims that have become a prominent dimension of legal and policy debate. And that may not be just the sentencing phase where victims have interest. They might have interest elsewhere, for example, at plea bargaining and other parts of the process. I also, if you say, well, that's the model penal code, that's just a bunch of academics or something like that, I would challenge you to consider, is there cultural acceptance of victim impact statements? And I'll cite, you know, one of the famous cases happened down the road here in California. Chanel Miller was assaulted. I think many of you know the story. She was able to provide a victim impact statement, although the judge did not agree with all of her recommendations. But my point isn't whether there should have been a longer sentence or a shorter sentence there, whether the judge did or did not do the right thing. I would just challenge this group and some of our other speakers, wasn't it appropriate that Ms. Miller had an opportunity to address the judge and provide her remarks? And let me make some additional points as to why I think that was useful. And here I'll cite then Vice President Biden, who wrote a public letter to Ms. Doe, as she was known at the time. And here you can see what he wrote. He said that, I hope that your strength might prevent this crime from happening to someone else. Your bravery is breathtaking. The distribution of Miller's statement, some of you are aware, her statement went up on, I think, BuzzFeed or something along those lines, and then it was viewed millions and millions of times over the next weeks or two. And Vice President Biden concluding that this is creating conversation, this is drawing attention to these issues. Again, I'm not saying whether or not the sentence in that case should have been longer or shorter. I am saying that the procedural mechanism that was used, giving Ms. Miller an opportunity to speak, was something that I think was fairly widely accepted at the time. Let me see if I can come up with another example. So here's another example of the cultural acceptance in modern America of victim impact statements. Some of you will recall that in January of 2018, dozens of victims of Larry Nassar, some of them on the USA Gymnastics team, were allowed to speak during a week-long proceeding in Michigan. Judge Rosemary Aquilina allowed 168 direct and indirect victims to speak. These were nationally televised. And as far as I can tell, there was widespread public approval of the victim's opportunity to speak. And interestingly, in that case, the sentence had already been determined. The plea bargain had set up some kind of an arrangement. So none of the victims were speaking to try to get a longer sentence or a shorter sentence, but they were speaking because they wanted to call attention to the crime, alert the judge, alert Mr. Nassar to the consequences of this crime, call attention to institutions such as Michigan State University, who had turned a blind eye to the abuse. And again, I think that I don't know, I'll throw it out to this group. I think there was general cultural acceptance of the right of the women to make those kinds of statements. And if you're interested, I cite my current article, but just last year in 2024 in the Marquette Law Review, Professor Ayers and I go through in some detail, we dissect the statements and try to figure out what were common features of the statements and what were individualized features. Spoiler alert, I'll tell you what our article concluded is that there were 168 victims, and direct and indirect, who all experienced victimization in unique and different ways, and that providing the victim impact statement was, to some degree, healing. I'm a little bit reluctant to use that word, but certainly there was some degree of catharsis from the victims having an opportunity to speak. Let's see if I can come up with another example. I know one of our speakers later today will be speaking on victims of state violence. And I'm speaking today about general victims' rights. I'm not drilling into particular kinds of victims. For example, this morning I'm not speaking about the special needs or concerns of persons who are victimized on account of race, gender identity, sexual orientation, immigration status. Those are all very important areas, but in talking broadly about the victims' rights movement, I'm speaking today about victims as victims. But it is, as an illustration, when someone is a victim of police violence, for example, the George Floyd case, who gets to speak at the sentencing? The family did. And again, I throw this out. I don't think there was a lot of controversy that the Floyd family was able to speak at the sentencing of Derek Chauvin. It seemed to me that generally the culture has accepted the right of victims, including victims of police violence, to be able to speak at sentencing. And just one last, no, I guess those are examples. So I would make the point, and I throw out the challenge to those who are critical of the victims' rights movement, critical of victim impact statements, to explain why in these examples it was somehow not just, it was a bad idea or something that would not be acceptable. It seems to me that America today, many countries today, accept victim impact statements as a matter of course. Well, let's talk also about some other developments in the victims' rights movement. Victims' rights are now part of the federal criminal justice system. The CVRA, Crime Victims' Rights Act, provides this list of 8 rights, again, pretty similar to the Florida amendment that we were looking at just a bit ago, the right to be reasonably protected, right to notices, right to be heard, for example, to be heard at sentencing, there in item 4 that we've just talked about. The Crime Victims' Rights Act was amended in 2015. I had been litigating for many years a case down in the Southern District of Florida, the Jeffrey Epstein case, where I represented victims pro bono who had been kept in the dark about a plea deal that was executed in favor of a very wealthy and well-connected individual. And part of the failures that were highlighted there were failure to be informed in a timely manner of any plea bargain or deferred prosecution agreements. So Senator Feinstein was nice enough to introduce an amendment and improve the CVRA by adding that item. And also item 10, the right to be informed of the rights and the services described in other laws. So this is what we have in the federal criminal justice system these days. And I think essentially what's going on, I'm going to borrow a slide that Meg's organization, National Crime Victim Law Institute, prepared. But what we're seeing then as the Crime Victims' Rights Act is litigated, for example, here in the Ninth Circuit, Judge Kaczynski wrote that the criminal justice system has long functioned on the assumption that crime victims should behave like good Victorian children, seen but not heard. The CVRA sought to change this by making victims independent participants in the criminal justice process. So if you're trying to conceptualize theoretically, we spend a lot more time about this, but the National Crime Victims Law Institute, I think, has come up with a graphic here that pretty much captures what the movement is trying to do. You'll notice, of course, your conventional, I don't know, in a conventional moot court setting here or something like it, 2 tables, one for the prosecution, one for the defense. The crime victims' rights movement has argued, no, wait a minute, we need a 3rd table in the courtroom. Not that victims are going to dictate the outcome, but that victims are going to have a voice in the process as the criminal justice process moves forward. And to give you just a couple of examples of how this is a move forward, these will be examples that I'm familiar with since I was representing pro bono victims in various cases. One case that sort of illustrates this is U.S. versus Paroline versus Amy. It was truly a 3-sided case. When I argued this in the U.S. Supreme Court, they took the 60 minutes of time and allocated it 20-20-20. This was a case where Amy was the pseudonym of the victim. She had been victimized by what we would call today child sex abuse imagery. She had significant psychological damages, and federal restitution law gave her a right to recover those damages. Let's say that's $1 million in damages. Well, who would pay for that? Paroline was one of quite literally tens of thousands of individuals who had viewed those images online, causing the damage to Amy. Our position was that, well, Amy should be able to collect the full amount from Mr. Paroline, and then if he wants to go chase down the other 10,000 people and sue them in contribution and so forth, he should be able to do that. But the innocent victim of crime should be able to collect jointly and severably the full amount of damages from one individual. Mr. Paroline's position was, hey, who the heck can figure this out? There are 10,000 people out there. How can we sort out who's responsible for anything? So I should have to pay 0. And the Justice Department took an intermediate position that said, $5,000 or something like that will be about right. And the Supreme Court essentially went with the government's position, but suggested that what needed to happen here was that Congress should step in and come up with an appropriate restitution scheme. That was over the dissent of, very strong dissent, an excellent dissent of Justice Sotomayor, who agreed with my position that there should be full restitution coming from Paroline. And later, Congress, yes, sometimes they do get work done. My home state senator, Senator Orrin Hatch, a Republican from Utah, and Chuck Schumer, a Democrat from New York, put together the Amy, Vicky, and Andy Act to provide appropriate restitution awards in these kinds of cases. So again, this is an illustration of the movement speaking, having a voice in the process, and moving things, I think, forward. I think it's also important, and I know Meg's going to talk about this in her talk. There are, when we think about the criminal justice system, a lot of times well-connected, powerful, and wealthy individuals or organizations can take advantage of the system and obtain results that maybe they're able to get out of the prosecutor that the public thinks are inappropriate. I could spend a long time talking about this case, but I currently represent pro bono a number of families who lost loved ones in the crashes of 2 Boeing 737 MAX aircraft. I'll simplify the story. Boeing lied, people died. It's that simple. Boeing concealed safety problems in the 737 MAX. Those safety problems came to light tragically on a Lion Air flight and later an Ethiopian Air flight when 346 people were killed. So Boeing cut a nice sweetheart plea deal where they paid some money but didn't have to admit to killing anyone. And for the last 4 years, I've been litigating in the Northern District of Texas on behalf of those families, arguing that that secret deal, just like the Epstein deal was secret, violated the Federal Crime Victims' Rights Act, and the judge down in Texas has agreed with me. The proceedings right now have kind of moved forward to what kind of a plea deal is Boeing going to get, and I guess we'll find out in the next couple of weeks. But the Fifth Circuit said that the victims very much did have a right to be heard or entitled to be recognized as victims. And again, this is an example where I think crime victims' rights provide a useful check on the system that might otherwise involve government and Boeing getting together to cook up a secret deal without taking into account families and others who have been harmed by a crime. Well, so I have just a few minutes left. Let me just wrap up here, and then there'll be some time for questions. What about the future of the crime victims' rights movement? Where is it going to go? And here I propose at the end of my paper kind of an agenda for the victims' rights movement, things that they might look at. At the top of my list, and the next speaker I think will be amplifying this point as well, we need to expand victims' access to legal counsel. The only reason that, for example, in my Boeing case, the victims are able to be effectively heard there is they found me to represent them pro bono. But that kind of legal knowledge and ability to spend hundreds and hundreds of hours on a case doesn't come across in every case. And so we need to think about ways of providing greater access to legal counsel. We need a Gideon versus Wainwright movement or moment for the crime victims' rights movement where we start to recognize that victims need legal counsel. Another issue that I think comes up is we do have these open-ended provisions in the crime victims' rights amendments. What does it mean to treat a victim with fairness, respect, and dignity? That is language there. Of course, similar sort of open-ended language protecting defendants' rights has been expanded over the years, and I think it might be time to do the same thing with these open-ended provisions for crime victims. I also think we need to have a discussion in this country about low crime clearance rates. And let me be clear, I'm not talking about making sentences longer. What I'm talking about is catching bad guys. Right now, 21% of serious crimes are cleared, and ultimately there's a conviction rate of about 4%. So for example, let's just say a woman is raped in America today, fewer than 21% of those will be cleared, fewer than 4% of those will be ultimately lead to a sentence, sexual assault being an area that's tremendously under-enforced. But the same point can be made about robbery and a variety of other crimes as well. I think we need to think about ways of changing that. I think we also need to think about expanding victim involvement in the crime charging process, which would help address lack of prosecution in cases involving marginalized communities, for example, under enforcement of sexual assault laws. We'll be hearing today later from another speaker who will be talking about victims of law enforcement violence. One of the things to think about is if we expanded a victim's role in the charging process, that might be a very effective way of addressing under prosecution of those types of crimes to the extent that it occurs. The reason is, who decides whether the cops are charged today? Well, it's the public prosecutor. If victims had a voice in that process, it might lead to greater understanding and conceptions of who are victims and what kinds of charges ought to be filed. I think we also ought to think about developing alternatives to adversarial criminal justice. One of our speakers later today will be talking about restorative justice programs. I think some of those programs are good. Frankly, I think some of them are bad. The trick would be to try to figure out how to create appropriate restorative justice processes. Just to kind of flash forward what my thoughts are on this, I think generally these programs are good, provided that crime victims are not coerced into participating in them. Sometimes I think the victims are told, unless you have it out for them, why don't you look the other way or be merciful or something like that. And some victims, frankly, may want to do that, but some victims may not want to do that. As long as restorative justice options are an option for victims rather than a requirement, I think we should think very seriously about expanding those. And I think we need to expand modern state constitutional amendments like Marcy's Law. Ultimately, I think the victims' rights movement should continue its efforts to pass a federal constitutional amendment There were last hearings held in 2015 on a proposed federal constitutional amendment, which looks, we don't have time to go through all the details today, but goes through a list of rights that are, similar to the Florida and California and other amendments that we've been talking about. So in conclusion, rumble, 140 pages to get there, Casella? Well, yes. I mean, I think a lot to be said about the movement, and my article tries to develop the historical, legal, and theoretical grounds for a victims' rights movement. I tried to make 3 arguments stemming from history, current law, criminal law theory, like the model penal code, that make a compelling normative case for victims having participatory rights. The case for those rights does not hinge on any substantive outcome in criminal cases, and certainly not the claim that victims will punish defendants more harshly. The case develops from the procedural claim that American criminal justice now will function more fairly if victims' voices are included. Victims are now heard, they deserve to be heard, and the remaining question for the future is how and when to amplify that voice. So just in wrapping up, let me suggest we have distinguished speakers collected together. Let me suggest an agenda for the symposium today. My idea for this came from Professor Vitiello's book. I think he asked, let's ask this question: what does it get right and what does it get wrong? What does the victims' rights movement get right and what does it get wrong? And I think we should ask that question, but let's ask that as it applies to state constitutional victims' rights amendments and statutes found throughout the country today. So I propose for our agenda today, here's just, for example, the Florida Amendment, which is a prototypical example. So I'll be interested. I think we have a panel that's being billed as critics of the victims' rights movement. Well, here's 12 or so victims' rights. Which of these rights do you oppose? Can't we all get together and agree that victims should have the right, excuse me, to due process and be treated with fairness and respect for the victim's dignity? Is that really controversial? Let's skip down to, I don't know, the 6th one. The right to be heard in any public proceeding involving pretrial or other release. The domestic violence case, the defendant is going to be released. Shouldn't the victim be able to explain to the judge where she works, whether he's threatened her in the past? Again, not to dictate what the judge should do, but to give the judge that information. Can't we all agree that that's a good thing? Right to confer with the prosecuting attorney. Important decisions are being made in those cases. And they, in the modern system, are made by the district attorney and the district attorney's representatives. But shouldn't the victim have a right to at least pass along the victim's point of view on the case? Can't we all agree to that? And the last one, just to pick one at random, shouldn't the victims be told, as Kamala Harris and others do with the Marsy's Law notification? Shouldn't they know what their rights are in the process? I submit that each and every one of these rights is something that is desirable, and I hope the other speakers who will be speaking today agree with me. So happy to get your thoughts. By the way, Andrew, you told me to finish at 10:05. And this is going to be a first in American legal history. A law professor / lawyer did not run over time.
10:04, Paul. So we have the opportunity for questions, both among folks in the room, but also online. And I'll be able to field those questions.
Thank you, Andy.
Perhaps if I could ask one myself, though,
Sure.
Getting the front row seat to your talk. Your paper was written presumably in the last couple months, and in the last month, things have significantly changed with the Trump administration. And you mentioned the future being the increasing enforcement of victims' rights, and that might come at the detriment of the prosecutor with the 3 seats in the room model, or Professor Garvin's proposal about how there should be more advocacy, which might affect the prosecutor's role, and also the participatory rights of the victims' movement. And so I think it's fair to say that reducing the power of the executive and participatory rights in a democratic system are not Trump administration priorities. And so I wonder if you might make some comments about how the victims' rights movement will be affected by the Trump administration Justice Department.
Yeah, great question, obviously. Let me mention that today's Friday. 2 days ago on Wednesday, I had a lengthy blog post on the law professor's blog where I blogged the Volokh conspiracy. Some of you may have been following the Mayor Eric Adams case in New York, where famously there were charges filed against the mayor, and now the new administration has decided that those charges do not align with the current priorities of the Trump administration. And my long blog post, there's actually a series of 3 posts, first argues that is something that's within executive prerogative. Which cases are we going to pursue and which are we not going to pursue is a classic situation where we typically defer to the executive. And one of the points that I highlighted that I didn't really notice before, Mayor Adams has been deprived of a security clearance as a result of the charges that have been filed against him, which I find, frankly, just stunning. That the mayor of the nation's largest city, which is probably the #1 terrorist target in America, isn't being given all the information he needs because of these pending charges. Maybe the charges should move forward. Maybe he should be deprived of the security clearance. But my limited point would be it's within the realm of reason for the new administration to conclude that, look, we have other priorities here than what's going on with this public corruption case. My blog post, by the way, does not take an ultimate position on whether the charges should or should not be filed, but my blog post finally does mention, you won't be surprised, victims' rights. Is there a victim in the Mayor Adams case? None of the participants in either the Biden administration or the current administration have treated that case as involving a crime victim. But I worked through the indictment in that case, and one of the allegations is that the city of New York was defrauded of $10 million by the mayor by certifications that he was entitled to certain campaign funds that he was not entitled to. That very clearly makes New York City, an institution to be sure, but institutions can be victims, makes New York City a victim of that crime. And I think that case should move forward, having the city of New York with a voice in the process to explain, look, if these charges are going to be dropped, we're not going to have restitution, we're not going to get the $10 million back that we were defrauded of if the mayor were to be convicted of those cases. So I think your point is that a unitary executive theory and more power for the executive is the Trump administration agenda. I don't mean to speak to that one way or the other, but for those in the audience who are concerned about concentrations of executive power, you should be foursquare behind the victims' rights movement, which is trying to put an independent voice into the process, which would be a check on executive power.
Yes, question over here. Would you mind using the microphone so our online folks can hear? Professor
You've given us an
Vitiello?
awful lot to think about. Great presentation. But, so expanded rights of counsel. One, do you think that the Gideon has worked for impoverished criminal defendants? And if not, how would you get funding to expand rights where we're barely providing adequate right to counsel for criminal defendants?
So has it worked? I think it's certainly, Gideon versus Wainwright has certainly been better than a world without Gideon versus Wainwright. So I think it's worked to that degree. Are there examples of inadequate funding of defense services? Of course. So I hold no brief against inadequate funding for defense services. Those should be expanded to appropriate levels. But I don't see a trade-off between giving money to, it's not like let's take money away from Meg's organization and hand it over to the defense attorneys. I think we can do both. Famously, right now, the current new administration is running around finding examples of funds that are not being, in their view, spent appropriately. If we were to take 0.1% of those and provide them to Meg Garvin and the National Crime Victims Law Institute and then let them distribute them to various clinics around the country, that would be, I think, quite useful. Interestingly, in 2004, the Federal Crime Victims' Rights Act was passed by Senator Feinstein from California and Senator Kyle from Arizona. Part of that bill was, and I know Meg can speak about this at great length, but part of the bill provided for funding of a series of crime victims clinics around the country. And over time, the Justice Department, which was in charge of distributing the money, has figured out ways to cut back on that funding. Probably because the reasons Andrew and I were just talking about a moment ago, it's probably not high on the agenda historically to fund attorneys who might be critiquing, shall we say, the approaches of public prosecutors in the federal system or the state system. So I think we should be expanding to the extent needed, both defense services and services for victims.
Any additional questions?
Thanks for your great presentation. I was wondering, isn't there a risk of new victimization in victim impact statements? I'm thinking about cases of domestic violence. What if a battered woman or a raped wife says that she wants her offender to be released, or please, I don't want him to be punished. What do you think about this case? I'm not an expert of this issue, also because in Italy we don't have it. So forgive me if the question is not.
No, that is, it's a very interesting point you raise. Suppose that a victim of domestic violence, maybe because of circumstances or financial pressures or physical threats, has to make a statement that might be against her best interests or might lead to shorter punishment. By the way, that's an interesting question for the critics of the victims' rights movement, because oftentimes we're told that allowing victims to speak will lead to longer sentences. It may, as your hypothetical points out, lead to shorter sentences. I think a partial response, at least to the concerns that you raised, is that victim impact statements are always given at the discretion or option of a victim. No victim is ever forced to participate, and so if a domestic violence victim, for example, did not want to speak, the victim would not be required to do so. And again, I think we need to think about American criminal justice as covering a broad swath of crimes. You've put your finger quite wisely as a criminal law professor on what is probably the most challenging area for victims' rights, because the well-known cycle of violence in domestic violence cases may lead to victims of domestic violence first initially asserting victimization, then denying it, and back and forth it goes. But if we look at many other cases, for example, my Boeing case involving victims of a deception by a wealthy American company. If we look at the Paroline case, victims of child sexual abuse imagery, those kinds of cases don't pose the challenge that you're suggesting. So I would suggest that even if your challenge to 1% of the cases is correct, we should still allow victim impact statements to move forward in the other 99%.
I think we have one last question.
Yeah, thank you so much. It is working? Okay. Thank you so much for your presentation, Professor Cassell. You mentioned numerous times about the victim's right to notice of the rights, and I wanted to talk to you or ask you about whether or not the notice provided currently is meaningful. I know here in California, victims at best are handed a copy of their rights, which is written in legalese. What impact do you feel that has on minority victims and victims who are disadvantaged, have language barriers, et cetera, in accessing their rights? And what can be done to address that gap?
Right. That's a great question. And I'm hoping that government officials in the California criminal justice system will soon be working on addressing that as more people with familiarity with crime victims' rights come into the process. I'm smiling because, of course, for many years I know you've taught a very interesting class on crime victims' rights, and I'm sure your students, as you yourself are moving into criminal justice agencies, are now going to start thinking about these problems. We've been thinking about these problems, I guess, since 1977. And still have, I think, a lot of work to do. I mean, there are some superficial things. The Marsy's Law card in California is translated into various languages, so at least they can read it. But you've identified quite properly sort of a second-level barrier. Wait a minute, a lot of that, a right to notice of pretrial release or something along those lines, does that meaningfully convey the rights. That's where I think, and Meg, I'm sure will be able to amplify this a little bit, if there were expanded victims legal services where people could go to say, look, I'm trying to figure out what these rights mean, can you help me understand that? That would be one step. I also know that the California District Attorneys Association, among others, has put in place in many offices around the state and elsewhere victim service providers who do try to liaison between the prosecuting offices and victims. You would hope that prosecutors would have time to do that, but the reality is oftentimes they're extremely busy, and so many prosecutors' offices have set up, sometimes with volunteers, sometimes with paid employees, victim service providers who can try to translate those rights into something that's meaningful. But more needs to be done, and I'm sure California's evolving core of victims' rights interested officials will be addressing it soon.
Let's thank Paul. Thank you. Chair.
Second for Mike. Oh, that's one second. Just, is that right?
No, that's you.
Oh, here it is. Thank you. Sorry.
Yeah, sure. It's my great pleasure to introduce our next speaker. It was Meg Garvin. She is the Executive Director of the National Crime Victim Law Institute, a clinical professor of law at Lewis and Clark College of Law, and a leading expert on victims' rights. In that capacity, she has testified before Congress, state legislatures, and the Judicial Proceedings Panel on Sexual Assault in the Military. She also serves on the Defense Advisory Committee on Investigation, Prosecution, and Defense of Sexual Assault in the Armed Forces, and is a member of the Council on Criminal Justice. She previously served on the Victims Advisory Group of the U.S. Sentencing Commission, is co-chair of the ABA Criminal Justice Section Victims Committee, co-chair of the Oregon Attorney General's Crime Victims' Rights Task Force, and as a member of the Legislative and Public Policy Committee of the Oregon Attorney General's Sexual Assault Task Force. She has won numerous awards for her advocacy work in the area of crime victims' rights. Prior to joining the National Crime Victim Law Institute, Professor Garvin clerked for the Eighth Circuit Court of Appeals for Judge Donald Lay, practiced law in Minneapolis, Minnesota as well. Today, she'll be discussing the systemic role of the victim's advocate as a counterbalancing force to the prosecutor in the criminal justice system. Let's welcome Mike.
Good morning, everyone. How is everyone? Good. I kind of feel like maybe Mike and Paul should have gone back to back, right? There was definitely discussion happening right there. And though I also feel really teed up to talk about mine because my topic today is really about counsel for victims as part of the thought process on where are we going from here. And so that's what I'm going to focus on. I'm going to leave time for questions, and I hope we have a conversation about it. I am going to try and weave in at times, like, what does it actually look like when there's counsel for victims? But I may not be able to get to as many examples. So when we get to the conversation part, I hope we ground it, right? I want it to be a little bit of a conversation about practice. What does our criminal legal system actually look like, and what can it look like, right? So I'm going to start with a little bit of, well, actually, first I'll explain my title. How many folks know what an intermediate impossible is? Any improv folks in the room? This is my big push in law schools, that we should actually marry improv with law school because you learn how to respond in the moment to things. So we teach a class about improv at Lewis and Clark. So all you McGeorge folks, come to Lewis and Clark. The notion of an intermediate impossible doesn't come from improv, but it has been used in lots of creative spaces, and it comes out in the 1960s. And the notion that in order to think differently, in order to have lateral thinking, right, you need to sometimes propose something that seems impossible in order to get your brain unstuck, right? And more than 30 years ago, That was the first time I can find very clearly a call for victim counsel in the criminal justice system. And at the time, I believe when you look at that conversation from 3 decades ago, that notion was received in the community as an intermediate impossible, an impossible idea that maybe would lead to a better world through different ideas, but the idea itself was rejected. My talk, my paper, which is the 60-page or the 60-footnote version of a paper, though it came in late, is that we cannot continue to perceive a victim counsel as an intermediate impossible. It has to become recognized as a core part of a democratic check on a currently unchecked prosecutorial system. And that's where I'm going, right, with this. So I want to do a little bit of a brain moment. I was going to do this as a poll where you all had to participate, but I know our time is constrained, so I'm going to do it and ask you to authentically engage in it, though. Like, put yourself in a place where you have to think through the answer to what I say. So this is what is the first word that comes into your own brain? If you feel like shouting it out, you certainly can, but most of us don't have that comfort. When I tell you this statement: prosecutorial discretion in the American criminal justice or criminal legal system should be subject to timely checks rather than merely preemptive or post hoc reactionary checks. Feel that? What words pop in your head? What visceral reactions are you having to that? Right? Second one. What word or ideas come to your mind when I say victims should have independent legal counsel to represent them in criminal justice? In the history of this conversation, these two ideas have been put together at times, but I don't believe sufficiently, right? I believe they have been proceeding intellectually as well as in practice as two separate lines of discourse, and I think they need to come together more clearly now more than ever, right? And the reason I say I was very excited last weekend while my paper was due to the Law Review in December as a draft. On Sunday of this week, I was editing, and I was reading the New York Times. And in the New York Times, that's not wrong one. In the New York Times, there was a wonderful article about the Mayor Adams incident. And incident is such a vague word. The charges and now the motion to dismiss those charges pending. And part of the discussion was around prosecutorial discretion. I thought, oh, my paper actually is timely. And I'll put up a quote in just a minute about that. The notion, though, that victims should have lawyers is not new, right? I've already noted that for more than 3 decades, there has been some call for victims to have a lawyer in the criminal legal system, right? So here's a quote from 1992. This commentary, it was a publication, can serve only to draw attention to the newly emerging field of crime victim litigation and the legitimate need for young lawyers, law schools, the trial bar to consider it the stuff of which careers are made. 1992, a victim's lawyer said that. 2002, at a symposium at this law school by John Gillis and Doug Bluth, they had an article, and one of the headings was, "It's time to bring in the lawyers." 2015, quote, "It is apparent that independent lawyers for sexual assault victims," so now this is a narrow call for lawyers, "are needed to ensure victims can knowingly and voluntarily choose whether and when to engage in the criminal justice system, and having engaged, whether to exercise or waive any specific right." That was myself and Professor Bluth. And then just 2024, the criminal justice system needs both victim advocates and independent counsel for survivors to be seen and both seen and heard, right? So you're all thinking to yourselves right now, yours wasn't supposed to be the history paper. Why, why this essay? What am I saying differently? I am building on the discourse and trying to reframe it. The majority of these calls for victim counsel, including my own with Doug Bluth in 2015, were grounded in a few theoretical frameworks. Those frameworks included procedural due process for the victim, right? The notion that victims, just like accused persons, need to have procedural mechanisms in place so that they can understand and engage in systems such that they can increase their faith in system, right? That's notions of procedural justice that were first articulated in the 60s and have come forward, right? Some of this was grounded in that. Some of it was grounded in therapeutic justice, right? The notion that we should have systems that, while they might not be doing therapy themselves, should at least have therapeutic aspects so that they do no further harm, right? So the notion of preventing re-victimization of persons in the systems, right? Those were some of the calls for why have lawyers in the system. And what I want to lift up is the very micro calls that have been made about accountability, that victims' lawyers in the system can actually serve as the most timely check on the system of all of the checks that exist currently or that have been generally called for. And the notion that prosecutorial authority might need to be checked is also not new, right? This quote is the quote that showed up in the New York Times on Sunday where I was like, oh my gosh, right? Like it's right there again. So the prosecutor has more control over life, liberty, and reputation than any other person in America. While the prosecutor at his best, right, very gendered moment, is one of the most beneficent forces in our society. When he acts for malice or other base motives, he is one of the worst. This is a quote from 1940, the Federal Prosecutor article. It is quoted relatively frequently in the discourse and conversations around prosecutorial discretion and abuse in this country, right? And it is the notion that we have consolidated a lot of power, right, in our public prosecutors. Right, that discretion, that power did not always exist, right? Professor Cassell already talked us through a little bit of the history of when the victim had a central role, right, in colonization moments as well as post-constitutional moments in this country, right? It is also true that the prosecutorial discretion as we currently understand it was not always what it was in prosecutors in the country. Prosecutors at first in this country were predominantly appointed prosecutors, right? And then they emerged to be elected prosecutors with the idea that election would return local control to the prosecutor, right? That would serve as a check, right? So the notion that there is a lot of prosecutorial control, I am not saying that it is inherently bad that prosecutors control certain pieces, right? But they do decide who to charge, when to charge, what to charge, whether to offer a deferred prosecution, a non-prosecution, a plea agreement, what sentence to recommend, who to talk to about all of that, right? And there are some checks on them, right? I don't want to ignore that there are checks on prosecutorial discretion that exist and that have strength in them, nor do I want to ignore the myriad of calls that also exist right now for additional checks beyond the one I'm proposing. So what are some of the checks, right? They fall into a handful of buckets, right? There's the preemptive checks, the ones that are supposed to contain or put up the initial guardrails on prosecutors, right? Those are the legislative moments, right? You decide what's a crime, what's not at the legislative level, at least arguably, right? You set that out. That's a guardrail on prosecutors, right? Some of the, you can't really see, the font I chose is not fantastic, so I apologize for that. But a few things are italicized, and I'll just call those out. Those are things that are calls for increasing that check that are currently in the discourse, right? So one of those is increased decriminalization of certain crimes, right? That are things that are currently crimes as a way to change the guardrails. If the guardrails say this, right, if we change the definition of certain crimes, including decriminalization of certain things, including moves to decriminalize things that are, right, deemed minor drug offenses, right? Deemed things that actually tie to mental health crises as opposed to something else. Decriminalize survival crimes, right? Those would change where the guardrails are and can serve as a check on prosecutorial discretion preemptively, right? Another preemptive one is judicial oversight, in that arguably, if a prosecutor is taking certain actions in court, right, the court can prevent certain things to happen. I'll talk about that a little bit more. Internal office checks, right, can be a check, arguably. And then elections. Those can be preemptive checks because you choose who to put in office, and they generally have told you what they're going to do, right? At least an approach they're going to take. And there have been calls, and this is in italics, for increased data collection and transparency for elections so that our public actually knows what's happening, right? So that when they vote, they are voting in a knowing and intelligent way. Those are preemptive, right? Putting up guardrails. There's post hoc checks, right? After the fact, or reactionary checks on prosecutors. Elections are, again, they can be an upfront or an after the fact. External reviews of things that have happened in prosecutors' offices. And then recently, Professor Tong Yin from Lewis and Clark Law School has proposed, let's actually put in place civil causes of action on prosecutors, right? That would be a post hoc check, right? And then the question becomes, what is timely here? I can prevent you from doing something, I can react after you do it, but in the moment, when there is overreach or underreach of a prosecutor, when there is inclusion or exclusion, potentially on a discriminatory basis or just on a generalized bias basis, right? What is the check in the moment? And most of these fail. Maybe judicial, right? But generally speaking, prosecutor and defense are going to be presenting in the space. The Supreme Court has put several limits on the judicial's ability to be a meaningful check on prosecutors. So the question becomes, at least for me and for others, what about victim input and participation? There's been calls for increased victim input and participation over the years. And part of what I do in my essay is just talk about that. Like, what does it actually mean for victims to participate? And I draw, again, on some different theoretical models. Sherry Arnston talked generally about citizen participation and categorized it ranging from non-participation, actually, like when you really look at it, through tokenism up to citizen power, right? And that's talking about citizens generally. In ambiguous participant, we had more recently the articulation, Ian Edwards articulated in 2004. Well, let's take Arnston's idea and put it right onto victims. And then it came up with, well, there could be dispositive participation where the victim both has an obligation to participate and then actually has power and control. But if you go one step down, Ian articulates non-dispositive participation and lays out the idea of expression, information, consultation. And then in 2016, another theorist from Canada comes in and says, what about victim participation as an agent of accountability? And that's where I situate victims' lawyers as potentially helping to ensure that victim participation can serve the role of agent of accountability in our system. Not that it doesn't, victims' lawyers don't serve other roles. I am a firm proponent of procedural justice for victims, right? And for accused persons, right? However, what else can victim participation be? And I believe it can meaningfully be a check, right? But what does it look like when there's a victim's lawyer in the mix serving? How many of you have actually been in a court where a victim had a lawyer just about their rights in the case? In the US, yeah, great call, right? Because this is not a US conversation only, right? I work in Australia annually, working on victim lawyers there. The International Criminal Court has lawyers for victims, right? It is not just us, right? But in the US, in the domestic system, how many of you have been in a criminal court and observed a victim's rights lawyer in action? Besides Miriam, right? It is still something that it is hard to think about because most of us haven't seen it. I wrote down a few thoughts, and I know my time is running, but like thinking about what it looks like. So I just was reflecting this morning as Paul was talking about some cases, right, to just give you an idea, right, about what it can look like, particularly if you situate it as a check, right? So I worked on a case where a minor victim of crime, and I'm going to use some facts around these crimes, but not very much, and I hope to not cause any trauma moments now. Child victim found their murdered parent. Okay? They make the 911 call, and they are, I believe, 8 years old at the time. Okay? They make the 911 call. The case is moving through prosecution. Prosecution wants to use publicly, in an open courtroom, the 911 call, and doesn't want to tell the whole victim's family that is about to be played publicly just wants it to happen in front of them, right? We find this out through a side conversation. The victim's lawyer went in and said, at least close the courtroom. Micro moment, right? But that's a participatory moment exercising the victim's right to dignity, right? As a check on the prosecutor. Homicide victim's family, right? This is one where it would have been post hoc, but could we do something in advance? Numerous times we have seen homicide victims' families first see their loved ones deceased on the news, uncovered in the street, right? We have gone in on those cases and said, well, at least those photos can't be used in an open courtroom, right? On behalf of the victim's dignity. Little micro moments, let alone the unbelievable litigation that Paul has already described, right? There can be micro moments. In a case that is kind of the in-between moment of micro and macro, right, or micro and massive, right, is an example I put in my essay, which is the Syed v. Lee case, which many of you may know about from the podcast Serial, right? It was made very, very famous because of that podcast, right? But I want to talk about what most recently happened and how it is an example of victims' lawyers as a check, right? So the homicide conviction happened in the year 2000. Right? 2 decades, the prosecutor's office in Maryland defended the prosecution and the conviction, okay? I want to be very clear here, right? Improper convictions, actual innocence claims, as well as procedural claims of innocence should move forward with communication, right? That's my footnote. What happened here was there was a year-long investigation where the victim was barely informed of what was happening, an in-camera submission of evidence, and a closed-door hearing of what the Brady evidence was that would result in a motion for vacatur, and then a motion for vacatur of the conviction with less than 1 day's business notice to a victim who lived 3,000 miles away. You have a family member murdered. You're living across the country. You know something's happening, but you get 1 day's notice that the state that has been defending the prosecution for 22 plus years is now going to dismiss it. And you ask, could I at least be there? Could we have the hearing next week instead? And the court said, no, you can drive home from work right now, and we can proceed virtually. And that's what happened. And by the way, your lawyer can't talk, right? You can just say something. That's what happened. The victim, through counsel, appealed it timely. The prosecution actually then tried to nolo pros the case in order to dismiss the appeal, basically. And ultimately, the appellate court said that the violation of victim's right required a reinstatement of the conviction with proceedings that proceeded in a way that honored victim's rights. So from a victim's rights standpoint, or from an individual victim standpoint, yes, they got their rights. Yes, they're able to be heard at a future vacatur hearing. But equally important, the court noted that the evidence of the vacatur, right, the evidence of the Brady violation should never have really been done in closed doors because there's an accountability moment at issue. Right? Now, this is about undoing a vacatur of a conviction, but what about the other way, right? It can go both directions. The key elements, though, to make this happen, victims' rights provisions, standing for the victim, and victim counsel. There is no way that the majority of victims in this country could proceed as an accountability measure if they don't have counsel. The system is not set up for that. So where do we go? Right? And Mike already posed the question that is on the next slide, which is, can we learn lessons from Civil Gideon and from Gideon v. Wainwright in its first iteration, right, which is about defense counsel, right? Gideon established the notion that defendants should have counsel. In practice, right, it's not happening all the time, right? In practice, in Oregon, for instance, we are under lawsuit after lawsuit of we're not providing counsel. So this is not to say Gideon has been the answer to individuals' rights and getting counsel, but it lays the foundation for it, and it has also set up avenues for it. Civil Gideon came after Gideon v. Wainwright, and it says, For civil litigants who are indigent, there are certain moments that they should have counsel also, housing being one of them, certain benefits arguments being others. And there was a concerted effort to go after civil Gideon at the federal constitutional level under substantive and procedural due process. It has consistently been restricted. I won't go to say it's totally failed yet, but it has mostly failed, right? I think post-Dobbs, there's a different argument to be had, and there's a couple of folks writing about that. But mostly it's failed. But civil Gideon then took a different approach. Go jurisdiction by jurisdiction at a legislative level and identify the most vulnerable people in your community and put into place the right to counsel for them. Whether that be a housing moment, whether it be a benefits moment, I argue victims' rights moment. We have vulnerable people in our communities trying to navigate a system where prosecution has tremendous power and often co-opts their voice. And if they had counsel, they could both be empowered themselves, have procedural justice, and serve a check on the prosecutorial power. So my proposition is we simply cannot let victim counsel be a procedural luxury that only someone who finds Paul Cassell gets to have. That does not serve our communities. We must start having representation in order to have transparency, accountability, and fairness, and we need to stop thinking of this as some wild, crazy idea. It is not an intermediate impossible. It is actually a democratic requirement of our system, and I think we need to get there, even if it means local first. So, questions?
Thank you, Meg. Do we have any questions? Here, Professor Van Cleve.
Hi, thank you so much. I've enjoyed both of these presentations. It's a lot to think about. My comment or question really comes from reading Danielle Sered's book, Until We Reckon, who really makes the insight that it's a false dichotomy to talk about victims and accused persons. Many accused persons are victims themselves. And, you know, along the lines of your intermediate impossible, a phrase I love, you know, all of these reforms seek to work within our current system. And Daniel Sered's critique of our current system is it's not working for anybody. It is not working for people who are harmed. It is not working for people who cause harm. So shouldn't we be really thinking beyond our criminal justice system? You know, restorative justice, transformative justice, and she gives lots of, you know, great examples in that book. But rather than these little fixes and, you know, despite maybe the intent of the movement, it seems to me that it has been conscripted to support harsher sentences, to support mass incarceration, in particular by relying on things like crimes of sexual assault and domestic violence as a way to sort of bring in the quote-unquote women's movement, primarily concerned with that. So shouldn't we really be kind of looking beyond this for something that's going to really work? Because I think the other thing that Sered points out is, and I'm sorry, I'll be quick, is that victims are fed a story that you participate, you go through the system, this person gets convicted, and you use the word healed, although reluctant to use it, but that's the story they're told. And then when they're not, even if they've given a statement, I mean, Chanel Miller talks about all of the challenges she faced even after giving her impact statement. We're fed this story, that then they're fed this story, you'll be healed, and they're not. Yeah. So again, shouldn't we be looking beyond all of this?
So first of all, everyone should read Danielle's book. It's amazing, and her work is tremendous. So a couple of responses, and I'll go kind of in reverse order, and if I don't get to your first point, just remind me of it. So the first thing, right, that victims are fed a story. I actually think we need to situate ourselves there first, because that is problematic, but they are never fed that by their lawyers. So I work with victims pre-charging. And so does the military right now has a victims counsel program where every victim of sexual and domestic violence gets their own lawyer from time of incident forward. And I work with those lawyers as well as in my own practice, and a ton of the time is about the pros and cons analysis of whether to move even to reporting or not, right? So my thesis in part is to dispel they're told this, because they're told that by popular culture and by system actors at times, and that is problematic, right? You do not suddenly heal, right, from something, right? That is not how this works, and the system can cause harm, right? Absolutely. I think the data is clear, right? PTS symptoms, for anyone who goes through for the system, they never stay the same. They either go up, and for a small percentage they go down, but the majority they go up, whether it's an accused or a victim. So first point, victim counsel would help mitigate that they're told a story. And I think that's important, right? If you move up to this false dichotomy of victim and accused, or harmed doer and harmed, the data also supports that. Of course they're coming from same populations, in part because of the way we police, right? So let's be honest about that also, right? Where we police, where we don't police, where we prosecute, where we don't prosecute, that feeds into the data set, right? So that matters. What we do with that, though, I think is a both and. Do we have to look beyond the current system to restorative justice, to transitional justice, right? And actual, right, international conceptions of transitional justice can inform our thinking quite a bit, right? Do we have to do that? Yes. Does that mean that we do not make fixes in the current system that would help do micro disempowerment or micro taking apart of the current system? I don't think it means we ignore the current system only to go after the big fix of everything. It has to be a both and, because there are people going through the system today, and there are prosecutors overreaching today that need to be fixed. And so I think it's a both and. Yeah.
Hi, Meg. I have a follow-up question to that. Marcy's rights and similar laws across the nation, they include a great deal of narrative posturing often. There's not a great sense of empowerment, but it gives victims a false sense of empowerment often. I guess my question is, how does independent counsel or an agent of accountability help to increase deliberate empowerment, help to increase actual empowerment for victims?
Because I believe the victim's lawyer can activate the rights or help a survivor knowingly and voluntarily waive those rights, right? What's happening right now in daily practice in investigation and prosecution is folks are handed a sheet of paper that says you have some rights. There's very little explanation of what those rights could mean in practice. Victims either ask for all of them or they don't know to ask for any of them. If they don't ask for any of them, it's perceived as a waiver. Legally, should not be perceived as a waiver. That's not knowing and voluntary, right? And if they ask for all of the rights, they are left with system actors to try to make meaningful, right? So the notion of what is dignified treatment for a victim is left within the confines of someone within the system defining what they think is dignified treatment of the victim, right? What the right to be heard means is left within the confines of a system actor. If victims' counsel is there talking to a victim saying, you know, you have this right, let's talk about what it means, let's talk about when you could activate it, let's talk about the pros and cons of activating it for you, right? Your safety planning, your I want incarceration, I oppose incarceration, like let's talk about that. Then you choose to do it, and then I go into court, I file motion practice, I make sure you can do it. And that's a moment of empowerment, including declination of exercising rights. When you choose to decline to exercise your rights in a knowing and voluntary way, that is empowerment. So I think it can make a difference. I completely agree with you right now. Victims' rights are a rhetorical pat on the head in most situations. Thank you.
Let's thank Meg for her interesting talk. I'm sorry. I'm sorry.
If it's a great question.
Well, I mean, I'm a law student, so I'm not sure if it's...
It's a great
valid.
question then.
Okay.
Law students have the best questions.
Okay.
No offense to the rest of you.
So I worked the semester at the California Victims' Rights Resource Center, and it was really eye-opening because one of the resources provided is to inform the victim. There's also civil remedies you can pursue. Mm. So would the victim's attorney also have to be both criminal and civil to be able to protect or you know, fight for the rights of the victim if many of the remedies are civil? And that's my
Brilliant question. This is a brilliant question, and I will not consume tons of your break time to answer it, but I do want to answer it. So a couple of thoughts. One, there are civil remedies, right? There are victims' rights, and rights enforcement is about redress, timely redress in the criminal case. And then there are civil remedies against people as well, sometimes against system actors, sometimes against the primary perpetrator or accused of a crime, and then obviously, right, all the law students in the room, what are you also looking for in tort? Deep pockets, right? There is someone else, right, to go after, right? So you have these avenues. Right, victims' rights in part were about like let's actually ensure survivors don't have to go that route to find some level of recourse, right? Victims' lawyers, there are two pots of lawyers, right? There's tort lawyers and then there's victims' rights lawyers. Every now and then they cross over, but I will say rarely. And in part because in tort you're worried about recovery, right, in a different way than ensuring the procedural mechanisms of a fair and just outcome that include your voice. So for me, I'm a victims' rights lawyer, and if you ask me a tort question, I call up a friend, I phone a friend. And if you're my client, I actually refer you to someone. Sometimes we co-counsel, where I'm the lead on the criminal and they're the lead on the civil. Sometimes we just have a shared representation agreement where I can share confidential information. But I have no expertise in tort, and my only concern is survivor voice in the criminal. But I do believe from a holistic standpoint, survivors need access to both of those so that they can meaningfully choose the path of recovery they want and the path of process that they want. So it's, again, a both and a good lawyer moment right there. So thanks for the question.
We're going to take a break and reconvene at 11 or shortly thereafter.
We do have refreshments up above, and we have the bathrooms right by the entrances too. So, thank you.
We're going to be getting back together in about 2 minutes here. So hello, hello, hello. Thanks again to the Pacific Law Review for putting on this wonderful symposium and is celebrating what we're celebrating today. And so we're continuing on. I'm our second moderator for the second panel. I'm Leslie Gilo-Jacobs. I'm the Anthony Kennedy Chair, Professor, and Executive Director of our Capital Center. And teach various different things, but that's not as relevant today as what our panelists do and teach. Mike Vitiello is a distinguished professor of law here at McGeorge and a nationally recognized expert on criminal law, sentencing policy, and marijuana law. His work on 3 strikes has been cited by the United States Supreme Court and the California Supreme Court. His recently published book, The Victim Rights Movement, What It Gets Right and What It Gets Wrong, offers a measured overview of the successes and failures of the victims' rights movement, which I'm sure we'll hear more about today. He's been a member of the American Law Institute since 2002, and he's a faculty advisor for the University of Pacific Law Review. So the way we're going to run this is he'll get the floor for 20 minutes, and then we're going to hope for 10 minutes of questions, and then we'll turn to the next panelists.
Thank you. Can you hear me all right? Okay. So a couple of quick observations. Where's Kara Anderson? Kara and Tay really deserve a great deal of credit for organizing this. They've been fantastic to work with, including just chauffeuring the company around and just doing a great job in organizing it. And also special thanks to, so pleased with the whole, all of the scholars who are participating. Special pleasure in getting the 2 premier scholars in the country who are supportive of the victims' rights, Professors Cassell and Garvin, to participate. It's a great pleasure and a great honor. So let me just mention a couple of things to get into my remarks quickly, a couple of preliminary things, thoughts. One, when I was working on my book, I had conversations with various people, including my wife, and I realized that they thought I didn't have empathy for victims. That's not true. I have a great deal of empathy, and as you'll see, I have some policies that I think would go beyond what is in place now to help victims. I define victims a little bit more broadly. Professor Van Cleve alluded to that a few moments ago in one of her questions. I hope to have time to get there. Professor Cassell did say that members of this panel should really address where they disagree, why we don't agree with some of his procedural items. It wouldn't be very interesting if I just stood here and talked about where I agree with Professor Cassell. That would be quite boring. That would not be what we should do as academics, to have an open and honest debate about really hard policy questions. And I'll make clear some of our disagreements in a moment. But I do want it to be clear that there is some overlap and some support for efforts of people who really work hard to do good. Now, one quick observation, this was not going to be part of my remarks, but I did want to address something very specifically about whether victim impact statements, how they play out in non-capital cases. One thing, I have no objection, I don't think anybody should have any objection to victims participating as part of the criminal process. Whether their statements should influence the sentence is much more debatable. I think also that sometimes prosecutors, and I think Professor Garvin may have conceded this point or recognized this point, sometimes prosecutors tell victims they're going to get something out of proceedings, participating, that is a false promise. It is not adequate to treat the underlying post-traumatic stress disorder that they experience. So I think you have to be very clear on what victims are going to get out of participation. And then the other point that Professor Cassell made, and I don't disagree, the data are unclear, but probably in criminal sentences, apart from the death penalty, probably there's not much influence for a reason. Guideline systems don't give judges all that much discretion. Plea bargains are the rule of the roost, and so judges may be very hesitant to overturn a plea bargain where it's already been agreed upon. So let me go, though, to an important area where I think that I want to focus on some real differences between my view and Professor Cassell. He is right in his paper. He makes an observation that the victims' rights movement is not monolithic. He focused on only one part of the victims' rights movement. I want to go back to the origin story. And in my title, I talk about the ways in which the VRM, the race, class, I should have added gender. I'm not suggesting that people in the victims' rights movement are racist or classist, but what I want to point out are ways in which some of the policies that they advance have racially disparate impacts, class impacts, and the like. In the amount of time I have, there are only a couple of areas that I can cover, and I want to jump into the first one, and that is I want to go back to the origin story of the victims' rights movement. If you go back to the Warren Court years, the Warren Court did a lot of things that I think we should really support, greater equality, Brown versus Board of Education, for example, efforts to expand the rights of criminal defendants, Gideon versus Wainwright. We disagree on some areas. I don't know what your position is on Mapp versus Ohio. But one of the things that happened when the Warren Court was expanding rights of criminal defendants was it got pushback from, notably, Frank Carrington. And you cannot talk about the victims' rights movement without talking about the grandfather of the victims' rights movement. And I don't think you can dissociate yourself from the way in which Frank Carrington influenced the movement in ways that I happen to think are quite negative. So Frank Carrington took the court on. He said that the court's decisions mollycoddled criminals. He contended that the court's decisions increased crime rates, very debatable proposition. His rhetoric was picked up by Richard Nixon during the 1968 presidential campaign, and at least when Nixon used his rhetoric, it was a dog whistle, an appeal to white working class people based on racial animus. And that can't seriously be denied that some of his rhetoric was incorporated into at least Nixon. Fast forward to 1972, Carrington got more traction when the Supreme Court overturned, in a closely divided case with no clear majority view, the death penalty was struck down as unconstitutional in the United States. That gave Carrington more fuel. The Heritage Foundation funded his book, The Victims. And The Victims is a book that starts to articulate many of the policies that have been advanced by the victims' rights movement. And there is no doubt that part of Carrington's agenda was to increase the death penalty, to get the death penalty legalized again, and to have it applied, and also to increase prison sentences. Now, one of his accomplishments within the movement was, of course, his participation in the 1982 Attorney General's task force on violent crime, and that report, as Professor Cassell referred to, included many of the policies that eventually were essential to the movement, including victim impact statements. Okay, now, I want to be clear again, and I hope it's clear in my article. Professor Cassell and I disagree on whether the Baldus study really is methodologically sound or not. The study reported that the death penalty had racial components to it. The race of the victim, strong correlation, white victims more likely to get the death penalty, and then some correlation with the race of the defendant. Now, I'm not an empiricist, and I do think I quote other people, other studies, other than just law professors. There is some debate. He cites a study that says, no, the Baldus study was invalid, but look at the full literature. It is a complex literature, and I don't pretend that I can answer it. But I don't want to debate that now. I want to turn instead to how I see victim impact statements influencing the imposition of the death penalty, where there is some empirical support. Now again, whether you think the death penalty is in and of itself racially biased in its application, that's another issue. But let's see how I think we can look at the way in which victim impact statements work in death penalty cases. And my conclusion is that it has a racial bias. And I think an institution like ours that works against racism really should be very careful about endorsing something that creates racial bias in the death penalty. How might it influence the imposition of the death penalty based on race? I use an example when I talk about this issue, where you have two killers, identical in every way in terms of culpability. Stone cold killers who decide to shoot the first person they see on the street. One killer shoots a wealthy white person. The other killer shoots a black homeless person. All right. Their culpability is identical by hypothesis. Now, what's going to happen during the trial? Well, first of all, first-degree murder charges, based on my facts, very easily satisfied. But then what's going to happen at the sentencing phase? Well, we know what happens, and we don't have to guess. Guess who participates more frequently in giving victim impact statements in death penalty cases? More educated and whiter people. Not surprising, for a lot of reasons. Now, you might say, well, are they more likely to make statements that consistent with prosecutors' desire to have the death penalty imposed? Well, we don't have to guess again. White people are more pro-death penalty than minority people. Well, are those statements likely to be effective during the death penalty phase? In other words, sure, white people can come and testify in ways about their pain that might be more likely to increase the death penalty, but will juries be sympathetic? And here again, we don't have to guess. Why? Well, first of all, juries tend to credit testimony from people who are more like them. And juries in the United States are whiter than the communities from which they are pooled. Why? For a lot of reasons, but here are a couple of reasons. One, the United States Supreme Court said in 1986 that prosecutors cannot use peremptory challenges to get rid of jurors, prospective jurors, based on race. Well, that means we're going to get racially diverse juries. Well, not so, not so, because prosecutors can come forward with non-racial explanations for why they want to strike a juror. So Professor Cassell is a prospective juror, and as I am presenting, talking to the jury, he's scowling. And let's assume I want to use my peremptory, and they say, well, you wanted to get him off because he's a red-headed man. and I'm not allowed to discriminate against redheaded men. But I come forward with the explanation was that he always scowls when he looks at me. And the court, therefore, does not question my use of my peremptory challenge. Would prosecutors actually behave that way, coming forward with explanations, non-racial explanations, when they may have racially biased reasons for excluding jurors? You bet they do. Occasionally a memo will come out from a prosecutor's office explaining to lawyers in that office how to explain in non-biased, non-discriminatory terms how to get rid of a prospective juror. And we know over and over again that juries end up much whiter, as I say, than the communities from which they derive. Now, there are other reasons why I think juries are whiter than their communities, but we end up with juries that are whiter than the community, more sympathetic to white victims' statements, and that white victim statements are more likely to make, in effect, pro-death penalty statements. They're not allowed to say, well, I want the death penalty, but they're talking about their pain, and they're usually brought forward only by the prosecutor when they're going to support the death penalty. Now, I would urge you, I don't have enough time to talk about the specific case I have in mind, but there is a really good example of a victim impact statement in Professor Cassell's casebook. It involves, I think some of you know how the death penalty works since it's been reinstituted. Basically, it's a balancing process of aggravating and mitigating circumstances, and the jury's invited to decide whether the defendant really deserves the death penalty. And the death penalty is supposed to be only for the worst of the worst offenders. And so there's a case that he describes. It involved a 17-year-old defendant who, with two adults, attempted a botched carjacking. One of the victims resisted. He was killed. The 17-year-old shot him. And then the wife of the victim, also a victim, lived but was seriously injured and lay on the ground for a long time. At the sentencing hearing, the 17-year-old was described by a former DA in the community as capable of rehabilitation. He was a popular high school athlete. He had no criminal violence in his history. That would seem to be a case where the death penalty really would not be imposed. For those of you who are under about 25 or 26, whose brains have not fully formed, and if you're a male adolescent, you realize that we don't think you have very good impulse control, and that's a mitigating circumstance in death penalty, typically in death penalty, and generally in punishment as well. Well, what happened in the case? In my paper, I link it to Michael Luddick's impact statement. Michael Luddick, a prominent, at one point, federal judge on the Fourth Circuit Court of Appeals. When I read his victim impact statement, I want to impose the death penalty. It is passionate, it is profoundly, his pain is palpable. It led to the death penalty in a case where one has real difficulty believing that the death penalty would otherwise be imposed. Guess what? The perpetrator, by the way, I mentioned he was 17. He had two adult co-defendants who testified against him. Typically, when an adolescent is committing a crime with adults, that is considered a mitigating circumstance for the adolescent. We tend to focus on the adult perps. Now, add to the fact that the defendant in the case was black, and he was actually executed. Now, that to me is a case, a dramatic case, about how victim impact statements in death penalty litigation can work to create racial bias. Let me turn to a different, oh, by the way, I should add one other thing about the case. It was tried in Smith County in Texas, where the population, 20% black, and it was 100% white jury. Now, I want to go to a different issue. Again, so it seems to me that there's good evidence that victim impact statements can skew the death penalty along racial grounds. I want to talk about something else, too. Got to double check my time here so I don't go too long. I want to talk about the way in which the law and order wing of the victims' rights movement has led to dehumanization of people who have committed crimes. In the 1970s, there was a broad coalition in the United States, including people on the left, in the center, and on the right, to get rid of indeterminate sentencing. In fact, the first Governor, Jerry Brown, when he was a young man, led the efforts in the 1970s to abandon indeterminate sentencing. Indeterminate sentencing was basically, you got a very low minimum sentence with a possible longer sentence, and really the most important decisions were made at the back end through parole on the theory that when you got rehabilitated, there was no more need to continue to incarcerate you. Now, there were a lot of criticisms of it, but one of the core criticisms was that rehabilitation didn't work. Now, a lot of that was based on a prominent writer, Martinson, 1974 article saying rehabilitation didn't work. As the process moved forward, of course, by 1979, Martinson wrote an article and said, yeah, rehabilitation does work. You got to choose your right program, you got to focus on the right data. And this, of course, was before the time when we had a lot of big data. But the movement had started momentum. But by the time that, for example, guideline systems were put in place, it was in the 1980s, not only in the United States, the federal guideline system, and in state systems. The net effect was, by that point, the law and order wing of the victims' rights movement had really taken hold. And we ended up with punitive systems of punishment, mandatory minimum sentences, very long sentences, far longer than we needed for social protection. And that became the direction that the nation took. Within prisons, no more talk about rehabilitation for many reasons, punitive attitude. In my paper, and I wish you would take a close look at this, I spend a lot of time in the paper talking about a paper that my friend and colleague Clark Kelso did. I don't know if you know who Kelso is. He has served as the receiver for the California prison healthcare system for many years, and a traditional political conservative, by the way. And his paper is about the way in which we have dehumanized prisoners in so many ways. We see them as not fully human. And of course, it comes with very negative results, because most people get out of prison. And if you've treated them like animals and they come back out, the results are not good. Again, much of that goes back to the law and order wing of the victims' rights movement. In 1972, a New York corrections commissioner could talk about how all men were redeemable. Now, that was naive at the time, and it remains naive. But so, too, is the view of people who commit crimes as not fully human. So let me then go to, and again, there's more in the paper, but in the interest of time, I've got to move quickly. Reform agenda. One, even if you are a death penalty supporter, I would urge you to try to find ways to reduce the racial disparity in the death penalty. Or do what I would do. Although I'm not an absolutist, you know, if you ask me whether Adolf Eichmann should be executed, I might say yes. But by and large, I would urge you to think about ways in which we can reduce the racial disparity in the death penalty. I think there are other areas, though. One is I would urge you to rethink the way in which we view people who commit crimes, not as animals, but as human beings. And what I wanted then is to pick up with something Professor Van Cleve alluded to, and that is, who are people who commit crimes? And very often, they themselves have been victims. Anybody who's done any work with people who are on death row and who manages to read their biographies, you will realize that they have been victimized through extraordinary violence, neglect within their families, and the like. So here is just one small proposal, other than trying to get you to buy into my view to get rid of the death penalty. Here's something that would really make a difference in the United States: universal health care. One of the things that I credit the victims' rights movement with doing is expanding resources for crime victims so that they can get psychological and medical care. Well, what if we had a really effective national health care system, expand on that program? And here are two ways in which that would help victims. Not all victims qualify for the resources that are available, so you would now have a system that really provided all crime victims with resources that could help with the trauma of their experience. It would do something else too. It would reduce the number of victimizers in the system, because those people who themselves have been victimized might get care at the front end and not become victimizers. Oh, but it's naive. Is it? Let me let you in on a little secret. There are good data on this point. We had a natural experiment when Obamacare came into place, and here was the natural experiment. States that opted into expanded Medicaid found crime rates going down by comparison to states that refused to accept the Medicaid funds, where crime rates did not have the same downturn that states did where it works. So I agree that the people in the victims' rights movement are doing some very good things. I would suggest that we go forward a more radical notion about really expanding programs that really can help. And I'm not going to touch the third rail, but one other thing, if you read my book, think about gun regulation. Okay.
Mike, you want to stay up, or I go up here for? I'd be happy to go up here. I don't know what you'll have. Yes. So we have time for a couple of questions here. I'm sure that we may have a number of them, but please, anyone who'd like to ask a question, raise your hand so that I can see it. Oh, there we go.
Hi, Mike.
Oh, Glenn.
One of the things you said about the victims' rights movement is it was promoted by law and order conservatives. I consider that a great compliment to law and order conservatives. The other thing that nobody seems to be mentioning here, especially about impact statements, because I train hundreds of parole boards and their hearing officers, is the effect of victim impact statement can play upon emotion. Now, if the judge, the parole board, whatever it is, are motivated by emotion, that's wrong. And that's what I would teach them when I was training them. But it's a hard thing to do when you have some really horrible crimes, to control your emotions. But I think that's the danger that we need to be really addressing and figuring out how can we address taking the emotion out of decision making, whether it be a jury or judge, parole board member. Anyway, that's my question.
That wasn't a question. That was a very nice statement, and there's you and I may have some agreement on it, but.
Yep, Professor Van Cleve over here. Yeah, I think it was somebody else? Oh, you've got the, okay, go ahead.
Okay. My question is regarding the jury. So as you mentioned, a lot of juries are, more prominent, retired people. What do you suggest is a way to make it more multicultural and more diverse to reflect the communities? Because, a lot of people can opt out because they work or they have families.
Yeah.
So what should we do for that?
Well, that's a real, very interesting question. In other words, we tend to have these whiter juries, and Emmy is making a very important point, again, asking the best question of the day so far, the second time. I really have, well, I know from years ago when Clark Kelso and I did some work on grand juries, and we're trying to figure out how to diversify grand juries. And one of the things is you get a pittance for serving on grand juries. Same thing with petite juries. So your wage earners are not going to be able to take time off. It's a real hardship and the like. I don't know that we're willing to up the ante and make it more financially available. But otherwise, your point is well taken. It's going to be wealthier, whiter juries, and the pool is going to be whiter and wealthier. And then when you get to the selection process, people who are wage earners who really have, who are going to suffer by losing time from work, aren't going to be able to serve. So I don't have a quick answer other than making it more remunerative if you had to take off work. So no easy solution.
Okay, and one more question here from Professor Van Cleave.
So I just want to follow up on the point about emotion, because now there's an entire industry, as I understand it, in the context of the death penalty, to come up with even full-blown videos about the life and challenges and hardship of the person who is facing the death penalty. So now you've got emotion versus emotion, and leading to this whose life is more valuable. Which is inconsistent, I think, with some of the foundational, which again, so just a comment.
Yeah, no, another comment. Mariam wants to make a
we'll give you a
comment.
turn.
Thank you. So I just wanted to point something out. You mentioned that a lot of folks and victims may feel like the offender's an animal and look at them as an animal, and I personally take offense to that, and just wanted to point that out because a lot of crime is committed by family or friends, and they often do want to go through a restorative practice. They don't want to go through our criminal legal system, and they're often forced into that.
Well, let me make a quick response.
Sure.
I didn't say all victims did by any means.
Sure,
And
absolutely.
certainly so.
Yeah.
I certainly would not want to offend you.
Well, I appreciate that. Second is about access. So you talked about that that victim impact statement that was really eloquent and would have made you vote for the death penalty. However, for somebody to be able to provide such a victim impact statement, it seems like they need to be wealthy and have access to resources that would help them understand the process and get to the point where they're participating. So victims of color and victims from marginalized communities who have the same rights and are not able to participate in our process due to barriers that Meg and Paul talked about, do you feel like things should be done to ensure that they have the ability to participate equally and use those constitutional rights that they have to participate versus just shunning them in the process?
I want to make a very qualified answer to that. It's one of the really nice things about participating in an event like this. I want to make a qualified answer that it's a really exciting thing about participating in an event like this. And I hadn't really thought it through until listening to Professors Cassell and Garvin. And I'm open to it. I don't want to jump too quickly because I haven't had time to think it through. And I understand that part of your work, at least I heard third hand, that you were increasingly aware of the need really to address racial and social issues within our program, and so I would applaud that as well. But I'm not going to, nothing is going down in writing. I got to think it through. I'm a slow learner.
Okay, did you want to make a comment?
Just a quick point. Sometimes professors are accused of being in the ivory tower and talking about things that don't have very much practical application. And that thought came to mind when I hear you talking spending a lot of time today about the death penalty. We're here in California. The last execution, as I understand it, was 2006. Moratorium seems unlikely to be lifted, imposed in
California.
In California. And in that same period of time, literally millions of prosecutions have moved through the California criminal justice system. So even if the victims' rights movement, I'm not authorized to speak for them, but if they stipulated to your point about the death penalty, isn't the more significant issue what's happening in millions and millions and millions of other cases?
Yeah, of course. By the way, I hope some of my students are here. I got to close on this one remark. So I told my students, especially in my first year, that they should come because I knew that Professor Cassell was going to beat up on me and that they would probably get a kick out of seeing it. I mentioned to them that in his article, he cites me 33 times. I have not run all those citations down, but I noticed one nice one, and I'll highlight that. But again, I think I'm out of time.
Okay. Oh, well. All right. So I have the honor of introducing our next panelist, who is appearing remotely. And should I start right now?
Give me just
okay. I guess if I have a moment, I just can't resist following up with Professor Vitiello. The way he responded to Professor Cassell's remark, which is, Professor Cassell said, isn't the more significant issue, all the non-death penalty prosecutions? And you said, yes, of course, but do you hold the same position about victim impact statements with all the prosecutions that aren't death penalty? Yes. I'm talking to Mike. Oh. I know you do.
Here, look, I'm not against victim impact statements in context where they are not, let victims come forward and talk about their pain. I'm very hesitant to see it influence the amount of sentence.
The sentencing, okay.
But there's something else, though. I don't think it has a profound impact there, largely because of guilty pleas and guideline systems that limit the amount that judges would then be influenced by the victim impact statements.
Okay, interesting. I hope people heard his response, but it's interesting to me to hear the difference between the two, not being an expert at all in criminal law. Thank you. Okay, now I do indeed have the honor of introducing Professor Nadia Banteka. She's the Gary and Salin Pajic Professor of Law at Florida State University College of Law. She was here for a while before going over there, down there, wherever that is. A leading scholar in constitutional criminal procedure, criminal law, law and technology, and international law. Professor Banteka's research explores critical issues in policing, AI integration, and in the criminal justice system, and AI personhood. Professor Banteka's work has recently been featured in a number of top law reviews, including Virginia Law Review, UCLA Law Review, Vanderbilt Law Review, as well as leading specialty journals, including the Journal of Criminal Law and Criminology and the Virginia Journal of International Law. We're so pleased to have her join us and present her paper, which again will be 20 minutes, and then question and answer afterwards.
Thank you so much. Can you hear me okay? Yes. All right, I see some hands up. Thank you very much for the invitation, and I'm really very sad to not be able to be there with you all, but it turns out that 6 years into a pandemic, COVID finally got me, and I guess you can't travel with COVID even in 2025. I guess that's the right thing to do, right? So instead, I'm over here in Florida. Thank you so much for the invitation to the Law Review that has a lot of my former students, to my former colleagues, and for the opportunity to present today. Any errors I'm going to say are due to COVID brain fog. And anything that I say right is due to me, right? So that's how I'm going to proceed today. My paper is titled "Unequal Justice: The Rise of Victims' Rights and the Denial of Justice for Victims of State Violence." And I want to tell you a little bit about the genesis of the paper before I dive into the content. So when my former colleague Mike Vitiello reached out about the symposium, I didn't know what I was going to write about, but I was thinking I was going to write something about victims and the criminal legal system and the rights of victims' rights in the criminal legal system. And I do write something about that. But what I didn't expect at that time was that I was going to be writing something else before that sort of prompted me to think of the questions, the question of victims' rights in perhaps a more holistic way than I was anticipating. So this is this paper, and I'll give you the context and the various relevant parts. So I suspect many of those who spoke before me, and definitely the keynote, having read that paper, sort of covered this, but I'll use it for context. Right, over the last several decades, the victims rights movement has reshaped the legal landscape as we knew it. Laws like the sort of older statutory victims' rights laws that then were preceded by constitutional amendments like Marcy's laws and similar reforms were sort of designed to center victims in the criminal process, ensuring that they have rights like the right to be notified for proceedings, the right to be heard in sentencing, the right to sort of have their privacy and personal safety protected. And so the movement was essentially a response to a legal system that was perceived as too focused on defendants' rights. And the idea was that that system ignored or marginalized victims. So the movement seeks to empower, and I'm oversimplifying here, but in a sense seeks to empower victims by giving them a greater role in the criminal process. Now, this movement, these new laws, I argue in the paper, were sort of built around a specific type of victim, perhaps not intentionally. I think not intentionally. But that type of victim was a victim harmed by an individual person, a person who's committing a crime and in the process of this crime victimized somebody else. Those laws were not intended to build around the state being the victimizing party. And I think this distinction is critical, and it's one I try to explore in the paper. So victims of private violence, so those harmed by individuals, have gained significant legal recognition through the victims' rights movement. But I argue that victims of state violence, so those harmed by police or other government actors, have been systematically excluded, both de facto and de jure. So both as a byproduct of the law and a byproduct of how the law is applied. And I think that this exclusion operates in two key ways. It operates differently in the criminal legal system, and it operates differently in the civil legal system. And I think this exclusion exists in both systems. So in the criminal legal system, where victims of police violence technically should receive protections under victims' rights laws, they rarely do. And I'm going to talk more about this. But as I argue in the paper, this is because police officers are almost never prosecuted. We have the data for that. And I'm also going to talk about another sort of mechanism that shields police officers from prosecution and accountability in the criminal legal system, and also denies victimhood from victims of state-sanctioned violence. In the civil legal system, victims of police violence face also significant barriers to redress, especially through doctrines like qualified immunity and permissive excessive force standards, which prevent them from seeking justice in the courts. Now, unlike criminal law, victimhood does not translate into legal protections in the civil cases, even though these individuals are often litigants. And they carry the powers of litigating parties. So this two-tier system of victimhood, victims of private violence versus victims of state violence, I argue in the paper, reinforces state power while denying justice to those harmed by the state. So what I do in the paper is I explore this dynamic and how it plays out and what reforms are needed to ensure equal justice for all victims. And this is what I'm going to talk about in more detail. So the modern victims' rights movement gained momentum in the late 20th century. Though it goes before that, largely as a response, as I mentioned, to the concerns that the criminal legal system was too defendant-focused, too focused on defendants' rights. And advocates pushed for laws that ensured victims had a role in the criminal proceedings, protections against retaliation and harassment. But these laws, again, were built around a particular kind of victim, one harmed by an individual, not the state. So as a consequence, victims of private violence receive extensive protections, while victims of state violence often receive none, for the reasons I address soon. Victims' rights laws have expanded, and some argue and some might disagree with that, but I would suggest that they have expanded carceral power, which is state power, reinforcing tough on crime policies disproportionately impacting marginalized communities. And these are the very same communities that are typically harmed by state violence. So those same communities are essentially victimized both by the victim rights movement and some of the laws that have been passed to advance that, and also by the sort of invisibility they have as victims in the existing legal system. So I recently wrote a paper called Policing as Injustice. And in that paper, I try to explore how the way policing operates today is often perceived, and the lack of redress for victims of police violence and misconduct is often perceived by courts as an unfortunate incident, as a misfortune that is a fluke instead of an injustice. And I try to turn that around and say that this is not the case. And I think the way victims of state violence are treated by the legal system is one paradigmatic manifestation of how policing and policing violence and state-sanctioned violence are an injustice as opposed to a misfortune. So the question I ask in the paper is essentially this: if the legal system advancing victims' rights is truly about ensuring justice for victims, then can it really fulfill that goal if it excludes, in practice, the people who are most harmed by state violence? And as I mentioned in sort of my introduction and summary, this exclusion plays out in both the criminal and the civil legal systems, which is what I want to turn to now. So the criminal legal system, if victims' rights laws were applied consistently, victims of police violence would technically have the same rights as victims of private crime, including the right to be informed, the right to be heard, confidentiality protections. But in practice, these rights are rarely realized. And we see two major ways in which victims of police violence are denied justice. The first is prosecutors rarely charge police officers who commit violence, even when there is clear evidence of excessive force. The reasons for this are mostly structural. Prosecutors work closely with police and rely on them for other cases, so that creates a conflict of interest. The legal standards we have for police use of excessive force, like the standards set in Graham v. Connor, give police wide discretion in using and justifying force. And we have plenty of data that show the very, very few officers are ever charged. And those who are charged, very, very few are convicted. Even in highly sensationalized cases, we see this absence of prosecutions and convictions. So in short, victims of police violence technically could benefit from victims' rights protections in the criminal legal system, but only if the officers who harmed them were actually charged and prosecuted. And this lack of protection effectively strips them of those rights. Now, rather than being held accountable, police often position themselves as victims in violent encounters to avoid criminal liability. I wrote about this in a paper titled Unconstitutional Police Pretext that came out with the Wisconsin Law Review. And what I unfolded in that paper was a new tactic that police departments are undertaking. And I did a survey on this in California and Florida and found that in both these states, this is rampant. And it sort of goes like this. They have a tactic of pretextual victimhood. So what happens is officers routinely, and police departments, routinely reframe incidents between citizens and individuals and officers to portray themselves as the ones under attack, as the victim of a crime. So they will do things like claim self-defense, even when the video contradicts. But most importantly, what they do is they file cross complaints against civilians, saying that it is the civilian who committed a crime against the police officer when the police officers were performing policing. So the civilian resisted arrest. The civilian assaulted the officer. So what that does is it turns officers into victims, right? And essentially what that means is it turns potential defendants, who are the officers who potentially used excessive force or violence against an individual, turns defendants into victims of crime. And that flips the legal narrative, shifting from perpetrator to victim to shield officers from accountability by using our victims' rights framework, especially from public accountability, because as we all well know, victims' rights include several provisions about privacy, and police officers and departments very much use those safeguards for privacy to shield their names from publication and for public shaming for excessive violence of various individuals, officers, and also police departments. And this tactic also distorts legal outcomes, making it even less likely the victims of police violence will receive justice. So while victims' rights laws theoretically apply to victims of police violence, the systemic failure to prosecute and also the systemic failure to sort of identify and remedy this flipping of roles that police officers can undertake thanks to victims' rights laws renders these rights meaningless. So that's on the criminal legal system. But one thing I didn't expect to do in this paper is talk about the civil legal system. And for me, that's sort of the more interesting contribution of the piece. So oftentimes when criminal prosecution fails, which it does a lot for police officers, victims of police violence will turn to civil lawsuits, typically under Section 1983. But in this case, too, the legal system denies them justice. This time mostly through qualified immunity, the doctrine of qualified immunity. So qualified immunity is the legal doctrine that essentially prevents victims of state violence and misconduct from successfully suing police officers and police departments and cities for constitutional violations unless these victims, who are now plaintiffs, can point to a near identical prior case where a court has ruled that the officer's actions were unlawful. So this means that even egregious cases of police violence are often dismissed because no exact precedent exists, and courts routinely deny victims their day in court, shutting down lawsuits before they even begin. Because of this, victims of police violence fall into essentially a legal black hole. They're denied justice in criminal courts, and they're shut out from redress in civil courts. So what this means is a victim of police violence who cannot access the criminal legal system because an officer wasn't charged, wasn't prosecuted, or an officer essentially turned themselves into the victim of a crime instead of the defendant who used force against the civilian. That also, all that sort of blocks the victim from being the victim of a crime, of a state-sanctioned crime, from being recognized as a victim in criminal court. And the civil legal system is also inaccessible because doctrines like qualified immunity essentially shut that same victim, now plaintiff, out of court. And the way this legal system is constructed essentially denies victims of state violence their victim status entirely. So the question is, how do we fix this? And I try to think of how to do this mostly in the civil legal system, because much ink has been spilled on sort of what do we do about the absence of prosecution of police officers, and some reforms have taken place in different states. Most of them, at least with the data we have right now, have been largely unsuccessful. But I argue that if we truly care about victims' rights, we need to recalibrate our legal system to truly protect victims of state violence. So in the paper, I argue for 4 key reforms, that some of which may already exist but are not recognized as such or particularized to victims of state violence, that I think could help balance the scales, mostly centered on civil litigation. And all these reforms sort of track reforms that were paramount in the victims' rights movement within the criminal legal system. So the first one has to do with confidentiality and protection from retaliation by the state. Remember, I said many individuals victimized by state violence will file Section 1983 claims against police officers for misconduct. But the truth is that not all litigants in cases of police violence and misconduct are created equal. Whereas most litigants enjoy procedural protections by virtue of their role as a party in a dispute, many don't in practice due to their identity or status. And this is becoming increasingly clear in the new administration. So consider, for instance, non-citizens who want to file a 1983 claim against officers for police misconduct. I've seen a ton of those cases. Those non-citizens might reasonably be worried that the state will retaliate against them for filing that lawsuit and share their information with ICE if they file a lawsuit against the state. So I argue in the paper that courts should have a way in cases of sort of 1983 or state equivalent civil tort actions against police officers and other state officials, they should find a way to limit the scope of discoverable information that the state can get about victims of state violence, or institute more broadly and perhaps presumptively a protective order for some of the information, some of the relevant identifying information, by allowing victims of state violence to file lawsuits under seal, to prevent retaliation, or provide some other way to designate information as confidential. This, in a way, tracks and builds on or builds an analog with the criminal law system victim right to prevent disclosure of information or records that could be used to locate and harass victims or the victim's family, or that could disclose confidential or privileged information of the victim. The second proposal I have has to do with victim notification in pattern and practice lawsuits, sort of Monell type of lawsuits. So in pattern and practice lawsuits against police departments, litigants will claim that a police department has engaged for a long time in a pattern or practice of misconduct and violence. And in the process of filing that lawsuit, they will get records and information and discovery about a potential unconstitutional pattern or practice of police departments, right? This is long, protracted time periods and a lot of discovery. Now, due to the very nature of this discovery, looking into patterns of abuse, plaintiffs could discover information about potential other victims of these patterns or practices. So when lawsuits against police departments reveal patterns of abuse, victims who were unaware of their legal claims should have the right to be notified. And so I argue in the paper that we should make a right for those victims to be not notified about their status as a potential victim, either to file individual lawsuits or join class actions. Most of these times, though, these lawsuits settle. And they settle often before summary judgment, but after surviving a motion to dismiss. And when these lawsuits settle, I argue that states and localities should be required to publish a notice so other potential victims of state violence and misconduct can join class actions or file individual lawsuits. Now, if you think about it, this aligns with sort of victims' rights in criminal procedure that include the right to be informed of your rights, the right to seek advice of counsel with respect to your rights, and the right to sort of making these rights available to the general public in terms of information. The third reform I propose in the paper is that state and localities should institute, in order to implement the reform I just spoke of, should institute some kind of independent entity or authority where these class-like claims can appear. So this can be a type of private attorney general or other office that is established in jurisdictions with perhaps, or start to be established in jurisdictions with systemic police misconduct claims and allegations to help victims who cannot find legal representation have access to it. What else we can do, and this also tracks victims' rights in the criminal legal system, is have the type of collective reparation funds to compensate victims of state violence that are similar to the kind of historic victim compensation funds that existed back before public prosecutions for victims came into the forefront for those individuals to recover. And the last thing is essentially catch-all, which is the right to be informed of all those new civil victims' rights. So victims in civil cases should have the right, civil cases against state violence should have the same right as criminal law victims to be informed of their rights and to seek counsel. So I think that these reforms would bring civil victims, sort of civil rights victims, protections in line with the protections that victims of crime get, ensuring that victims of police violence are no longer ignored in our legal system. So just to wrap up, essentially what I argue is that despite the expansion of victims' rights laws, victims of police violence remain legally unprotected and at times and too often legally invisible. In the criminal legal system, victims of police brutality should be protected by victims' rights. Yet this doesn't happen. In the civil system, victims face procedural barriers which block them from seeking redress and access to court, and this allows them any meaningful way of turning themselves into a victimized party that is worthy of redress, essentially turning them into invisible victims. So if victim rights laws are truly about protecting all victims, then I argue that they must be responsive to victims of state violence through some sort of meaningful reform. And I hope that some of the reforms that I propose are sufficiently meaningful to at least move the conversation in the room. So I'll be happy to answer any questions. And I'm going to minimize my screen so I can see you better.
Hi, this is Paul Cassell. Thank you for that very interesting talk. And I want to extend to you a sincere invitation from the crime victims' rights movement to join us in our battle against the state monopoly over criminal prosecution. You are exactly right that in America today, state officials get to make the final decision on whether other state actors are going to be charged. That's been a common critique of the victims' rights movement of the current system. And if you go back historically to the system of private prosecution, that would probably be the most powerful remedy available to address that problem of lack of prosecution of public officials. You also mentioned the idea of a private attorney general for civil cases. The victims' rights movement, of course, has been very enthusiastic and interested in exactly those kinds of reforms in the criminal justice system. So I guess I don't know, I'm now commenting rather than questioning, but I guess I would comment that I feel like you should join us as we attempt to storm the barricades of the state monopoly on criminal justice charging function, and we look forward to having you become a comrade in arms in the victims' rights movement.
All right, we got more? Here we go.
Hello, my name is Roxanne, and I wanted to ask about one of your suggestions for reform, specifically about publishing the settlements in order to then get recognition for, case precedent for things to move forward that way. Do you think that if those settlements are published, then that would hinder the desire from either party to even move to settlement, and if that would hinder or propel then the victims' right movement in that sense?
Are you able to answer?
Oh, sure. I thought I was collecting questions. Okay. Yes, absolutely. So to Professor Cassell, well, I guess this is a comment in response to comment, and I'll say this, and I think there's an appetite for this generally and you probably know it just as well as I do in both criminal scholarship and sort of civil scholarship. I was at Penn Law for a talk, I think it was in December, and I was presenting a paper I recently wrote called Police Vigilantism. And it was interesting to me, and the reason why I raised this is because it was interesting to me to hear that most folks in the room wanted to talk exactly about this question of public versus private justice. And I think this question comes up in sort of like across the spectrum of what we would think as traditional legal scholarship, right? It comes up in the sort of victims' rights-oriented accounts. It comes up in the more abolitionism-oriented accounts, right? It seems to me that essentially both ends or many ends of the four quadrant of legal scholarship seem to be right now grappling with the state's inability to provide sufficient redress and justice to individuals. Interestingly, I think my paper took more of the civil turn, in part because many of these suggestions do exist in the victims' rights movement, but also in part because I think ultimately I give myself pause and I am surprised that it didn't start there. I would have thought that victims of state violence would perhaps have been the first archetype of victim that we would have started our questioning of how we want to get them to justice. Now, that doesn't mean that there is something inherently wrong by this, but it did give me pause that we started from a system, the criminal legal system, that is, at least the way it's designed today, foundationally more difficult to strike a balance. Now, of course, that was not always the criminal legal system we had, but I will join you in thinking about this question of private versus public justice, and what that means for our legal system overall, because I think this is a very, very interesting question. Now, Roxanne asked the question for publishing settlements, and I should have spoken more on this. I am not arguing that we should publish the settlements themselves. What I argue is that we should that states and localities should publish a notice that there has been a settlement, and what that settlement involved, not in terms of how much money was paid out or who the parties were, but a notice that there's been a settlement of a pattern and practice and practice case, or even an individual case. But mostly I was thinking of sort of the kind of Monell lawsuits, so that individuals can know that even though, somebody settled such a case, because the nature of these kinds of investigations and discovery tends to be communal, right? A pattern and practice of abuse that has settled. Of course, police departments don't admit fault when they settle these cases, but it is possible that there might be more victims of state violence than the person who filed one lawsuit. So what I advocate is the localities and states should have an obligation to publish a notice for the settlement, so that other people who might have been victimized by said pattern or practice can at least be aware that there was a lawsuit and the lawsuit settled, and perhaps be alert at the fact that their own experience of police violence and misconduct could be part of that pattern or practice.
Okay, well, thank you so much.
Thank you very much.
It was good to see you. And
good to see you too.
Okay. So we will move on to our next panelist. Our next panelist is Professor Erica Nyberg-Birch, and she's a clinical professor and director of the Farm Worker and Immigration Rights Clinic at Florida State University as well, College of Law. In this role, she supervises students representing immigrants and workers with a focus on immigrants in removal proceedings. Prior to joining FSU Law, she was a senior litigation associate at Boies Schiller Flexner, LLP, where she engaged in high-stakes litigation and maintained an active pro bono practice. During her career, she's worked as an attorney at the ACLU of Pennsylvania and the Bronx Defenders. Her scholarship addressing the constitutional limits on immigration detention was published in the Notre Dame Law Review. We're so pleased to have her with us today.
Great. Thank you all so much for having me. I'm really excited to speak with you and appreciate you accommodating this remote format. I know that I stand between you and a slightly delayed lunch, so I'll do my best to get us through this and get you to lunch on just a little bit late. So I'm going to go ahead and share a PowerPoint now. Let me just make sure you can see. All right, so as you can see, today I'm talking with you about my paper titled Eroding Victim Protections in the Age of Crimmigration. And in this paper, I argue that the increasing criminalization of immigration law has diluted the efficacy of statutory protections for immigrant victims of crime. These protections are enshrined in a series of laws that have recognized that individuals without formal immigration status face particular vulnerabilities as a result of their lack of status. Yet the contemporaneous blurring of the lines between immigration and criminal enforcement has made it more likely that a non-citizen will become the target of enforcement, and that enforcement will render them ineligible for these forms of immigration protection. This article unpacks the consequences of this enforcement paradigm for non-citizens by focusing on 3 recent developments in federal immigration law and policy that illustrate these consequences. So before we talk about those 3 recent developments, let's take a look at the statutory protections that currently exist. So into the early 1990s, the spousal residency petition process shifted control to abusive spouses who could wield the threat of deportation in coercing and silencing their partners. In 1994, as part of the Violence Against Women Act, Congress created a self-petitioning process for non-citizens whose U.S. citizen or resident spouse was subjecting them to extreme cruelty or battery. While this self-petition process provided a pathway for some survivors of spousal abuse, it didn't address vulnerabilities faced by victims of other forms of abuse who feared that if they reached out to the police, those same police tasked with protecting them would enforce immigration law against them instead. So in 2000, as part of the Victims of Trafficking and Violence Prevention Act, Congress introduced the U visa, which is a non-immigrant visa for victims of a series of crimes, including domestic violence-related crimes, exploitation-related crimes, and a number of other violent offenses. And this process requires that the non-citizen cooperate with law enforcement in an investigation into the crime. And as a result of cooperating in this process, this person becomes eligible for a non-immigrant visa that can then become a pathway to lawful permanent residency. Now, that same act also created the T visa, the trafficking visa, which is a visa for victims of sex trafficking and severe forms of labor trafficking. Of note, with each of these forms of relief, VAWA, U visa, and T visa, they all exclude individuals with certain criminal convictions, including minor drug possession crimes, unless they can prove eligibility for a discretionary inadmissibility waiver. Now, while advocates applauded Congress for protections for survivors of domestic violence and crime, many have argued that the congressional investment in a law enforcement paradigm has watered down the protections in practice. Now, I argue that this law enforcement framework that dominated the responses to domestic violence has also influenced the approach to immigration enforcement in a way that has watered down these protections with a particular consequence for non-citizen victims of crime. So contemporaneous with the Battered Spouse Waiver Program and the passage of VAWA, Congress made contacts with the criminal legal system a central focus of an expanded immigration enforcement system. These changes expanded, for example, the criminal grounds of removal and inadmissibility, and they also created a basis for the federal government to hold someone in mandatory immigration detention. So again, at the same time as Congress was authorizing appropriations for law enforcement through VAWA, it also channeled a great amount of federal funds to both militarize the southern border and then also expand internal enforcement. And so around 2000, right, the same time as the U visa process is being enacted, Congress was turning the same state and local law enforcement agencies responsible for protecting non-citizen victims of crime into a tool in the immigration enforcement arsenal. And so, you know, we've seen in recent weeks a central focus on these forms of cooperation between state and local law enforcement and ICE officers, right? Those were born around the same time as the U visa went into effect. Similarly, in the years following the creation of the T visa, the federal government also increasingly prosecuted individuals under a long dormant federal criminal provision for unlawful entry and unlawful reentry. These prosecutions have increased the likelihood that individuals who were trafficked into the country or who were extorted by a smuggler would actually become the defendants in federal prosecutions instead of protected through the T visa program. Recently, non-citizens who would be eligible for these victim-based protections, including T visa, U visa, and VAWA, have even greater reason to fear encounters with local and state law enforcement. As I discussed in my forthcoming article, The War on Immigrants, states are increasingly criminalizing violations of federal immigration law. So non-citizens now could face criminal investigation and prosecution for immigration crimes in state courts where they can access these federal victim-based protections. So I argue that the increasing criminalization of migration and the ongoing intertwining of criminal law enforcement and immigration enforcement has resulted in differential treatment of non-citizens in their encounters with police and law enforcement, other law enforcement officers. Yet the humanitarian protections that Congress created for non-citizen victims of violence haven't been amended to reflect these changes. For example, they still exclude individuals with criminal records, even minor ones, and they still require cooperation with law enforcement, even when such cooperation puts individuals at risk of immigration enforcement. So I look at 3 recent legislative and policy developments that illustrate these trends. So first, the House of Representatives recently passed and sent to the Senate H.R. 30, which would expand the grounds of inadmissibility to include broadly defined domestic violence offenses, as well as child abandonment and neglect. Now, while the legislators introducing this bill have proposed it as a way to protect victims, many victim services organizations from around the country have raised alarm bells, urging the Senate to reject the proposal as a threat to immigrant victims. They emphasize that this law would give abusers another threatened consequence, another threat to wield against their victims by threatening that they could call law enforcement, and such a call would result in someone being subject to removal and without access to humanitarian relief. And in the context of mandatory arrest and prosecution policies, these advocates predict that many victims will be rendered inadmissible under this same bill that's purportedly supposed to protect victims. This proposed change would also replicate the exclusionary consequences of already existing immigration policies that often define conduct born of coercion and economic necessity as a grounds to exclude people from victim-based protections. Next, increased enforcement measures have been threatened, and these enforcement measures would also impose greater vulnerabilities on non-citizen victims. So at the federal level, there's been a great deal of publicity around the first one of these changes, right, which is the rescission of a policy protecting individuals in certain sensitive locations. So in the context of victims of violence, right, they become vulnerable to ICE prosecutions, arrests in shelters, in hospitals, right, in places where they might go to seek assistance. And in addition, the acting director of ICE, contemporaneously with the rescission of that policy, also rescinded a 2011 policy providing for prosecutorial discretion for certain victims, witnesses, and plaintiffs. These efforts are paralleled by similar efforts at a state level, as states are redirecting law enforcement efforts away from preventing crime and addressing violence at a local level and towards enforcing immigration law. As a result, many immigrant victims further fear cooperating with law enforcement and may choose not to seek out help. As a result, they would remain vulnerable to violence while being unable to access the statutory protections that require their cooperation with law enforcement as a prerequisite to relief. Finally, Congress has recently expanded mandatory detention to include individuals with a mere arrest. Under the Lake and Riley Act, individuals who are arrested for shoplifting and other theft offenses are subject to mandatory detention for the duration of their removal proceedings. Now, these individuals could have been subject to detention before. The difference is now they're not eligible for a bond hearing where they could prove they are neither a danger to the community nor do they present a risk of flight. This law doesn't make any exceptions for minor children, for victims of human trafficking and domestic violence, or other populations that might commit crimes out of force or desperation. Those who are subject to mandatory detention face a heightened risk of re-victimization, as detained individuals and whistleblowers have reported routine sexual violence and even forced sterilizations. Survivors would be forced to endure this continued violence during the lengthy period of it while their applications for U visa, for T visa, for VAWA are pending before USCIS, which can take years to process. In addition, many immigration judges in the past have refused to continue proceedings to await that decision from USCIS and instead have ordered immediate deportation. Under either scenario, whether they wait or whether they're subjected to removal, applicants are often barred from accessing victim-based protections. To address the vulnerabilities, the immigration system, I argue, must attend to the complex realities of violence and marginalization. The immigration system itself makes people more vulnerable to victimization by conditioning access to legal rights, social services, family unity, and personal liberty on immigration status. While a more protective system would decouple immigration regulation from law enforcement and expand access to formal rights, recent legislative changes suggest that we will see more harmful federal state policies before any pendulum swings in the opposite direction. In the absence of formal recognition, we should support the work of community organizers building safe spaces for community self-determination in the absence of formal safe spaces. We should also see these efforts as essential to democratic integrity. The current legislative trend reflects the reality that many people most impacted by these harmful policies don't have access to traditional forms of political participation. Protecting spaces for civic participation and mutual aid is thus integral in mitigating this threat to democratic legitimacy. Thank you so much for your attention, and I look forward to your questions.
Thank you so much. And let's see, as people digest it all, whether we've got a question or two. A lot to think about, given what's going on. Integration of the victim rights with immigration law. I wonder if any of the, should I put the spotlight over here, any comments or thoughts? Yes, Professor Van Cleve can always be counted upon to participate in many different ways. Thank you.
So I guess mainly a comment. I really just appreciate both this presentation and the prior one, kind of challenging us to think more broadly about victims of crime and how, we should be, if we're talking about these rights of victims, it should be inclusive. So I just wanted to comment that I really appreciate that.
Oh, and it looks like we do have the microphone going somewhere. I saw you running.
Yeah, I saw him.
Oh, okay. Here we go. We do have another question.
Thank you for the presentation. So we were talking about how victims' rights, victims have the right to exercise them or not to exercise them. But as you mentioned, some of the barriers of victims not having access to reporting the crime, how that can affect them by not being eligible for immigration reliefs. That's something that we often see. Also, them having barriers in different areas, such as like compensation through the state. So it's a lot of barriers that victims have, especially if they're immigrants in this country. Since you're also in a part of an institution, what recommendations do you have for our school, for other law schools, on things that they can do to support their immigrant community?
Yeah, thanks. That's a lot of great points there. I think in addition to talking now about victims of crime, right? Another place where this comes up, right, is victims of labor exploitation, and you talk about not having access to remedies, and so that's something we see in the labor space where undocumented workers don't have full access to remedies for violation of their labor rights. So just another thing that your comment sparked in my mind. And in terms of recommendations, I think one of the consequences of some of the legislative and policy trends that I spoke of in this piece is a fear of existing in public spaces, right? A fear of accessing services. And so, one thing that our community is trying to do is help assist, if someone has to go to the hospital, like, do they have someone who can go with them to the hospital? If they want to report to the police, like we had a client who's being stalked as a result of threats to report her to ICE, actually. And so, how do you rally around people and make sure that the systems that are there to support them don't discount their experience, don't discount their value to the community, and take their reports seriously. And so I think sometimes being present, bearing witness, right, creating community spaces where, or participating in existing community spaces where people are trying to build safe spaces when those might otherwise be under threat as a matter of formal policy is one potential, not solution, but one potential step, right? And, I think what you all are doing, having conversations about this, coordinating symposium, attending the symposium, thinking broadly about who deserves protection and who should have a say in whether to report and how to report, and how that's taken seriously is another step in the right direction.
Oh, we do have one more question back here.
Thank you so much. So I just had a question kind of going off of the recommendations. We see a lot of people who, like you talked about the U visa, and I know that there's qualifying crimes, but we do see a lot of people left out of these protections because they are not necessarily considered victims. And this question is also, I guess, towards our other experts here. I think it was briefly talked about, like, well, what is a victim, and expanding what exactly that is. So in terms of recommendations for people who, have suffered or have been a victim in some way, maybe not the legal sense, of certain crimes, well, what resources can we provide them? I'm referring to the immigrant community. What resource can we provide to them? What, I guess, recourse or just some type of restitution, right, for these people that have been victims but don't have that legal protection or that legal status, or are able to qualify for a U visa or VAWA. And then I guess, yeah, just the comment towards our experts, like, well, has there been the conversation or thoughts on expansion or policy, right, for U visa or VAWA?
Yeah, thank you. So again, great point, right? There are, and it sounds like you've been having these conversations today, and I'm sorry to not be able to be there in person. There are a lot of crimes left out, right? The list of VAWA, the list of U visa qualifying offenses is long but limited, and so we end up in circumstances where you're in this perverse role as an attorney, where someone's telling you about a criminal contact, and it's sort of like, oh, too bad this other thing didn't happen, right? Which is, obviously you don't think that, but like in terms of relief, like there are these limitations that people are left out of this framework. And so in terms of like formal advocacy, there are groups that are advocating for an expansion of the definition of who qualifies for a U visa. Also another issue in U visa, TPC are the limitations on the number issued every year, the slowness of the process, right? And so that's another area of advocacy that those are certainly asks that have been put forward and are part of the conversation, even though the list remains somewhat narrow. And I think we could have another conversation about sort of the history of like why the crimes that are included and other crimes aren't included. But one, again, with this, like, I'm going to go back to the labor piece, but but that's one that comes to mind because of the sort of arbitrary distinction between like labor exploitation and labor trafficking, and labor exploitation doesn't always get protections, labor trafficking does, right? And so previously there was a deferred action for labor enforcement, so a system where you could seek deferral of deportation and certain protections if you had been exploited by an employer in some capacity. There are also civil suits, right? So even though sometimes a person might not be eligible for a U visa because the crime wasn't a qualifying crime, they may still be interested in pursuing civil suits. And we've seen that with consults we've done with people who have maybe not quite been eligible for a T visa because technicalities, right? But they still are interested in seeking restitution, and maybe that's under the TVPA, right? They bring a civil lawsuit for damages. But I think, you know, for people who are in law school or lawyers, like there are lots of creative ways to try to think about, you know, what is someone's goal? Like what would make them as close to whole as possible? And then how can we use the existing state, federal protections, short of immigration law, right, to try to help them at least get a little bit closer to their goal.
Okay, well, thank you so much, Professor Nyberg-Birch.
Thank you.
And thanks so much to all of you for being here and participating. And my understanding is indeed California time. It is lunchtime. So you are dismissed to do that. Thank you.
We have lunch available in the same room where you got breakfast, so go on back there and help yourself to whatever you want. We're coming back at 1:15.
Sumere. Okay. She's German. Okay. Not German. She's Italian. German. Okay.
Hello, everyone. Welcome back from lunch. My name is Rachel Van Cleve. I am currently a visiting professor here at McGeorge School of Law. And I've been invited to provide just a little bit of things to think about in the context of comparative law. I have taught comparative criminal justice, a course called Comparative #MeToo. I have focused on Italian criminal justice and specifically their law on sexual violence through one sabbatical when I was at Texas Tech and then 2 Fulbright grants since then. And so I wanted to start a little bit with some words of, I guess, advice in embarking on any comparative inquiry, comparative law inquiry. And these are from Günter Frankenberg and his piece that starts with the title, Critical Comparisons. And he compares comparative law to traveling, where you sort of leave your normal routine, try to shrug off your assumptions about things and start to learn something new. You go to a new place, you have to learn how to get around. Sometimes you have to learn the language. I also think of learning comparative or studying comparative law as analogous to learning a new language because some things don't always translate. And you learn more about, at least in my experience, when I learned Italian, I learned a lot more about English grammar in studying another language than I did when I was, in elementary school and learning English grammar. So this breakaway from the routine, from the familiar, and to being open to things different and new. But he also presents a couple words of caution. And I don't know if you've had the experience in traveling, but oftentimes, and in comparative study as well, oftentimes when we see something new, we try to fit it into the framework of the familiar, right? So we observe a criminal trial in another case and try to fit it into, okay, how does this line up with ours? How is it similar? How is it different? And his word of caution about that is it's not always going to work. Similar with language, things don't always translate. One sort of kind of classic example of that is the notary in the United States is generally not a lawyer. Might also be a lawyer, but doesn't have to be a lawyer in order to be a notary to just certify signatures. Whereas the notary in countries of the civil law tradition, like Italy, like France, South America, the notary is trained in the law and has a much broader function than just sort of certifying signatures. So that's just one example. And so the other concern that Frankenberg raises of this constantly trying to how is it similar, how is it different in the study of comparative law is it can lead us to be critical on the one hand, ours is better, or it can lead us to think, oh my gosh, this is just wonderful, and just become enamored with the other. The other is better. Meanwhile, sort of which is better is typically not the right question. It's almost like saying apples, oranges, which is better? Well, it can depend. And in the study of comparative law, it depends on history. It depends on culture. It depends on values, which all might have some similarities, but also have some differences. So in John Merriman's book, The Civil Law Tradition, which is written for lawyers from the common law tradition, our tradition, he talks about, hold on one second, the value, generally speaking, and the phrase I like to use is as compared to. The value in the civil law tradition, and I'm focused primarily on criminal law systems, is a value of certainty, that like people who are in similar situations and accused of crimes will be treated similarly and have similar outcomes, which is why countries like Italy of the civil law tradition really don't have a jury trial. There are some of the most serious offenses that might be tried with a mixed panel of professional judges and lay jurors, but otherwise they don't trust the idea of achieving some certainty of treating people similarly by leaving it to a jury trial. And so I say that by way of, we're going to have some very specific discussions of examples in other countries in this area, a subject of victims' rights and different procedures or policies in this area. And so I just want to remind us all that there's also a larger system at play and other choices that other countries have made with respect to their criminal justice systems. And the other thing that I would add to that is, once again, I think that comparative study, for me, the goal isn't so much to learn everything I can about the Italian criminal justice system, right, or the Italian law on sexual violence, although, you know, I read a lot of that. But it also provides a basis for critical and assessment of our own system, the things that we might take for granted. For example, we've heard some discussion of plea bargaining, which, you know, I think many of us in the common law tradition tend to think that's just normal. And while other countries like Italy have adopted forms of plea bargaining, it's different. They approach it somewhat differently and try to regulate it perhaps in a way as compared to our practice of plea bargaining. So just by word of caution from this inspiration from Guter Frankenberg, is keeping in mind there are broader decisions and choices that systems have made, and what works in one system might not translate well into another system. And again, one of my favorite phrases is as compared to, right? There are no absolutes, and also there are variations within the common law tradition, there are variations within the civil law tradition, but as compared to each other, we can sort of make some generalizations. all that, I also want to emphasize, though, that one thing that we see in comparative study is we are faced with very similar challenges, trying to come up with approaches for addressing challenges, the obstacles and challenges that victims of crime might face, and the like, and coming up with different approaches, again, grounded often in history, experience, culture, values. And not that we value different things, just we might have slightly different priorities as compared to the other. So you're in for a treat. I'm really excited to introduce to you our first speaker. Gianmarco Caletti is an adjunct professor of criminal law at the University of Bologna, where he's going to become a full-time senior researcher of criminal law at the Department of Legal Sciences in October of this year. At the same university, he obtained his PhD in criminal law in 2018. And from then till 2022, he was a research fellow at the Free University of Bolzano, working on the interdisciplinary research of CREEP, criminalizing revenge porn. He was a visiting scholar at the universities of Cambridge, NYU, and you mean Duke at Durham? Durham. Durham in UK, yes, different Durham. Among the first Italian scholars to deal with image-based abuse, he repeatedly advised national institutions. His research focuses on criminal negligence and recklessness, as well as on sexual violence offenses. He is the author of the first Italian book on consent in the area of sexual assault, and together with our second speaker, for this afternoon, he edited Criminalizing Intimate Image Abuse, a Comparative Perspective, which I've had the pleasure of reading and am finalizing my review of. So without further ado, I will turn it over to you. Thank you.
Good afternoon, everyone, and thank you, Professor Van Cleef, for this generous presentation. And I would like to express my gratitude to Professor Vitiello for this invitation. It is really a great pleasure to be here in this beautiful context, especially because I'm learning a lot about American criminal justice from prominent scholars. So it's an incredible opportunity for me. Thanks also to Tai and Cara for their kindness and for this wonderful organization. Well, this guy is Cesare Beccaria, the Italian author of the fundamental book Dei delitti e delle pene on crimes and penalties. And as well known, Beccaria is one of the founding fathers of the liberal paradigm of classic modern criminal law. Cornerstones of this paradigm are the publicization of criminal justice apparatus, which, as Professor Cassell reminded this morning, is a reaction to forms of private criminal justice triggered by the victim. The protection of society, but only within the limits outlined by the guarantees of criminal law. And finally, the concept of legal good. In Europe, criminal lawyers do not focus on the right or legal interest of the victim, but on the concept of legal good. This is a generic and depersonalized legal entity protected by the criminal offense, for example, sexual autonomy and rape, or the proper functioning of justice in false testimony. In Italy, we call it bene giuridico, and I've never found an attempt to translate into English. It is important to note that this concept of legal good, instead of victims' rights, express the objective nature of liberal criminal law. Criminal law is a matter between the state and the defendant. The individual interest of the victim is absorbed into the legal good, of which, however, the primary owner is the state. Anyway, the result of this liberal paradigm is that for a long time, victims played a marginal role in European criminal justice. The victim was a stranger into the criminal process. They had no procedural rights and powers. Their claims were incorporated into the public prosecution. It is noteworthy that the concept of victim itself has historically remained stranger for the legal vocabulary of both scholars and laws. In Italy, for instance, traditional vocabulary employs the expression of such as a person subjected to the offense, soggetto passivo del reato, and person offended by the offense, persona offesa dal reato. However, over recent decades, this perspective has shifted significantly. Even within the penal system of continental Europe, there has been a profound evolution in the role of victims. Although we still do not have in Europe a movement for victims as strong as those described by Professor Vitiello in his seminal book, criminal law policy of European states appears to be increasingly victim-oriented. European states have introduced new offenses, new rights for victims, strengthened their role in criminal proceeding, and promoted restorative justice practices. These shifts have been influenced by a range of historical, cultural, and social factors, including the rise of victimology and its result, but scholars agree that the inputs from the European Union, EU, and law, and the European Court of Human Rights case law have been pivotal in driving these changes. Today, I will try to provide a brief overview of how European law has evolved to give victims a more prominent role in criminal justice, highlighting both achievement and challenges. At the European level, two key frameworks have shaped the victim rights. The first one is the European Union's legislative framework. The EU has progressively introduced law to protect victims, starting with compensation rights in the 80s and later expanding to procedural rights and victim support services. The concern about compensation was to create a public fund for compensation in each member state. Why? Because the absence of this fund in one state can be an obstacle to a citizen who want to move in another state of the Union. The 2012 Victims' Rights Directive marked a major step forward, establishing minimum standards for victim protection across all member states. The second is the European Court of Human Rights case law. This court has recognized states' duty to protect victims through effective criminal laws and effective investigation as well. There are some landmark rulings, but we will see later. And just a clarification, those who already have a clear understanding of what I'm about to say will forgive me. The European Court of Human Rights is not the Court of European Union, but of the Council of Europe. The Council of Europe is the continent's leading human rights organization. Since its foundation after the Second World War, the organization has created a common legal space centered on the European Convention on Human Rights across its 46 members. From the picture, you can see that, for example, Turkey, which is not part of the EU, has joined the European Convention, or UK, which has left the EU, is still part of the Convention. Well, let's start with the EU. For much of its history, the European Union had no authority over criminal law, as it was considered as a domestic matter. The EU was initially focused on economic integration and criminal law, remaining strictly within the jurisdiction of individual member states. However, this changed with the Treaty of Maastricht, 1992, and the Treaty of Lisbon, 2009, which explicitly granted the EU the power to legislate on a certain serious crime with a cross-border dimension, such as terrorism, human trafficking, and financial fraud. like in a federal state, the idea is that the cross-border dimension of the crime justifies the intervention of the union. And despite these progresses, I want to point out that EU still does not have a unified criminal code, neither a model penal code. Instead, it influences national systems through harmonization of criminal law, requiring member states to adopt similar legal definition, especially of crimes, and penalties for certain crimes, judicial cooperation, and creation of supranational bodies like the European Public Prosecutor. One of the EU main contributions to criminal law has been the creation of a legal framework for victim protection. According to the Treaty on the Functioning of the European Union, the EU can establish a minimum standard to ensure victim rights across member states. And EU victim protection laws can be grouped into two categories: general protection for all victims. These measures focus on access to justice, on compensation, and on protection from secondary victimization. And the second group is our specific protection for vulnerable victims, imposing member states to introduce specific crimes or penalties. Those include victims of human trafficking, sexual exploitation, domestic violence, and terrorism. I cannot dwell on these last laws. I just want to make a controversial example. Italy, as the effect of a European directive on child pornography, has also criminalized totally virtual child pornography, where are not used images of a real child. And this choice does not seem entirely consistent with the arm principle, but please find more on this in my paper. Early EU initiatives focused primarily on compensation for victims of violent crime, but in recent years, the focus has expanded to include procedural rights, support services, and restorative justice. European law has introduced a set of rights for victims, which can be grouped into four main areas. The first one is participation in criminal proceedings, where victims now have the right to be heard and informed throughout the legal process. They can challenge prosecutorial decision and in some cases seek compensation directly through the criminal trial. The second area is protection from further harm. To prevent secondary victimization, European law requires that victims be treated with dignity and respect in court. And special measures exist to protect vulnerable victims, such as children or survivors of gender-based violence. The third area is access to support services. These are very important. EU law mandates free psychological, medical, and legal support for victims. The 2012 directive introduced the victim support helplines, specialized assistance programs, and better access to information. In the end, EU encourage mediation between victims and offender has become a priority, aiming to provide closure and reduce reoffending. But colleague Summerer will focus on this. As I said, the 2012 Victim Rights Directive establishes a framework based on four key principles. The first one is information. Victims have the right to clear and accessible information about their rights, the legal process, and available support services. This includes translation and interpretation services when necessary, because obviously there are many states involved and many citizens of many countries with different languages. Support. EU countries must provide free and confidential victim support services, including psychological assistance and legal aid. Protection. The directive introduced measures to prevent secondary victimization, such as minimizing contact between victims and offenders in court. For example, they are supposed to wait in different places when they are waiting for hearings. And special protections are provided for victims of domestic violence, child abuse, and hate crimes. And participation. Victims have the right to be heard and involved in criminal proceedings. Matto Leonatadakis will speak about this later. And they can appeal decision not to prosecute and claim compensation directly in court. Note, please, that this directive is about to be amended. There is a proposal which aims to reinforce some rights. Interestingly, victims will be able to report online, for example, but see more on my papers on this. One controversial issue is whether victims should have a role in sentencing. The European Court of Justice maintain a clear boundary. In Gaye and Sanchez has ruled that the victim should not dictate sentences outcomes, as this remains the state's responsibility. The principle behind this decision is that the justice must remain impartial and not be driven by personal retribution. I've chosen this image of the Hadrian Wall in Britain. It was insurmountable some years ago during the Roman Empire, but honestly, I don't know what's going to happen now. Let's now say something about the role of the European Court of Human Rights in protecting victims. Beyond the European Union, the European Convention on Human Rights and the European Court of Human Rights have significantly shaped victim protection in Europe. While the Convention does not explicitly mandate criminal laws to protect victims, the European Court of Human Rights has ruled that states have a duty to criminalize certain behaviors, such as sexual violence, torture, and forced labor, and that victims must have access to effective investigation and legal remedies. Some landmark cases includes X and Y versus the Netherlands, where the court ruled that the national law must effectively protect victims of sexual abuse, even when they cannot personally report the crime. MC versus Bulgaria, which is very important case, which established that the lack of consent, not physical resistance, defines sexual violence, and this case influenced many European legal reforms on sexual assault. Volodina versus Russia, yes, Russia was part of the convention. The court convicted Russia for failing to protect a victim of cyber violence, recognizing digital abuse as a serious form of harm, and recognizing that some forms of cyber violence has been punished with the criminal law. And JL versus Italy, where the European Court of Human Rights ruled against Italy for using gender stereotypes in a rape trial and in the decision, reinforcing the need to prevent secondary victimization. Please, on all these decisions, see more in my paper. While European law has made significant progress, several challenges remain. There are serious implementation gaps. Not all EU countries provide the same level of victim support. Some states have been slow to introduce compensation programs or specialized assistance programs. It's not difficult to guess why. All these measures need many resources, while introducing new crime or recognizing rights to victim is not apparently expensive. There are over-criminalization risks. The aim to protect victims has sometimes led to broad criminalization of new offenses, raising concern about proportionality and the effectiveness of criminal law. For example, Italy's strict laws on virtual child pornography that I've already mentioned, or think about, there is a recent directive about violence against women and girls that put a positive obligation to criminalize cyberflashing, and this criminal obligation has sparked a debate about the boundaries of criminal law and the respect of principles of criminal law as arm principle and criminal law as a last resort. And the third problem is balancing victim rights and fair trial principles. Strengthening victim participation must not come at the expense of defendants' rights, and courts must be ensured that victims are supported without compromising due process guarantees. But I think that my colleague Matto Leonatadakis will talk more about this. In conclusion, the role of victim in European criminal law has changed considerably. Once seen as a passive participants, they now have stronger rights, protection, and a greater voice in legal process. The EU and the Court of Human Rights have played a crucial role in this transformation, shaping laws that balance victim support with the need for a fair and impartial justice system. However, challenges remain, ensuring that all victims receive equal protection across Europe, preventing excessive criminalization, maintaining the integrity of the legal system are key issues for the future. The debate on victim rights will continue to evolve, but one thing is clear: victims are no longer invisible figures in criminal law. They are now recognized as key players in the pursuit of justice, but something gets right and something gets wrong.
Thank you. Any questions? Yes.
So your slide with Hadrian's Wall and the limitations on sentencing, my impression was that many European countries did allow victim impact statements at sentencing. And then when I read your paper and listened to your very interesting presentation today, I'm wondering if I'm wrong or if there's some nuance there about what's allowed at sentencing. Could you expand on that a little bit?
So you think that there is a trend towards the victim impact?
Yes. Even in Europe. And I had my slide that listed many European countries that I would categorize as having victim impact statements.
Currently.
Currently, yes.
Have victim.
But you are obviously closer to the situation than I am.
At the moment, there is this decision of the European Court of Justice, which is different from the European Court on Human Rights, because the European Court of Justice is the court of European Union, which is Gueye and Sanchez, 2011, and to the moment, it's so far, this is the landmark decision, and it was a case where Gueye and Sanchez were two convicted persons who failed to comply in order to come back home, and wives of these guys asked for permission for their husband to come back. But the European Court of Justice says that this statement by the victims was not in their interest because there was a serious danger of re-victimization given the fact that it was a case of domestic violence. And that's why I asked it before. And so now scholars obtained from this decision the idea that so far it's not permitted the participation of the victim in the sentencing stage. I don't know. I think that the trend is towards a reinforcement of the rights guaranteed from the victim rights from the directive of 2012. There is a proposal to amend the directive, and so, as I said, I've chosen this picture because there is a wall, but I don't know how long this wall will protect the sentencing phase from the participation of victims.
I'm just wondering if your conclusion is based on the civil party, where the victim can be the parte civile.
Yeah, the victim can be civil party, so can participate to the process, to the trial in order to get compensation. But at the end of the trial, the lawyer who represents the victim can ask and can quantify the harm, the damage that she suffered, that he or she suffered, but they can't. Obviously, they can't try to affirm criminal liability, but they can't ask, for example, for a certain kind of penalty or participate in deciding what kind of sanction is provided by the court.
Thank you.
So I have a question about a slide that you had earlier, where there was, I think, a guaranteed right for victims, unless I'm misremembering, to an effective investigation and a legal remedy. And based on my very limited knowledge of even American criminal law, guaranteeing a legal remedy seems maybe potentially an overstatement. Like, what do you do if there's not enough evidence in that investigation? How do you still come to protect that right that you've guaranteed for victims? How do you define a legal remedy in that sense?
Ad impossibilia nemo tenetur, we say, the Latin used to say. So if it's impossible to give evidence of a crime, obviously the state is not responsible. What the European Court of Human Rights require to member states is that they do serious investigation. For example, the case I mentioned, Volodina versus Russia, it was quite an easy case because it was a classic case where two persons were together. They have a romantic story, and then the man, after the breakup, the man upload on social networks some intimate images of Miss Volodina, and Russia was convicted because domestic authorities didn't do anything to understand who was the responsible of the crime, of the distribution of these images, and they dismissed several times the case, and so it was evident that they didn't want to prosecute the responsible of the crime. So I hope that I answered to your question. So there are some decisions of the European Court about the standards that a serious investigation has to meet in order not to be responsible for not guarantee a effective remedy to the victim.
Hello, thank you for your presentation. On your slide about the 4 pillars and the first one being participation, you indicated that victims could sometimes challenge the prosecutor's decision, and I was interested in hearing about how that would actually play out in real life. How would a challenge be brought? How far does it go? And who would decide whether the challenge was valid or not?
I can talk about Italy, but basically, if in Italy we have the principle of mandatory prosecution. So if a public prosecutor knows that a crime has been committed, is obliged to prosecute or to investigate. And if the public prosecutor decides to dismiss the case, victim can appeal, and the decision is made by a judge who can evaluate if the investigation has provided evidence and helped to understand who was the responsible of the crime. So the victim has the possibility to appeal to respect the principle of mandatory prosecution. The victim has the right to appeal against, for example, the decision of the prosecutor to dismiss the case without a legal basis or in contrast with the evidence of the investigation that he has conducted.
Thank you. Thank you so much. I love your presentation and your paper. I've been very intrigued by the European Court of Human Rights jurisprudence as it's been evolving around the right to dignity, which has mostly, as I've seen it, been happening most recently around like end-of-life kind of decisions, things like that. And I'm just curious about whether the general right to dignity jurisprudence out of the court has been being considered in the criminal context and victims very much, and what you're seeing in that space, if anything.
So dignity in, okay. Let's say that on this topic, I think that the main focus of the European Court of Human Rights is about secondary victimization. So they are very careful about the domestic proceeding, and that the domestic proceeding, during the domestic proceeding, the domestic authorities have treated the victim with dignity, and there are also many practical consequences of the jurisprudence on secondary victimization. For example, in Italy there is a lot of rules about testimony of the victim, especially when the victim is a vulnerable person. For example, the first hearing of the first time that the victim give his or her testimony, it is a private hearing without many persons, without the newspapers. It's a private hearing, so that the victim is not victimized again. And for the other example that I made, for example, is that the defendant and the victim should wait for the hearing in separate spaces, not to be together. Obviously, we have very old courts. You can imagine in Italy we have nobiliar palaces of many centuries ago, and so it's not always possible. But Yeah, the jurisprudence of European Court of Human Rights is very careful to this aspect of secondary victimization, and many countries are often convicted for violating this right to the victim to not be victimized again during the proceeding. Yeah. Obviously, the problem is to balance the cross-examination and the accusatory model of criminal procedure to the right to the victim not to be heard too many times about her crimes and about her story.
Great.
Especially in cases of sexual assault and...
Thank you very much. Thank you.
Good afternoon.
Hello, my name is Rachel Van Cleve. I'm just about to give your introduction.
I can't hear you.
Can't hear me?
Can you hear me?
We can hear you.
I can't hear you for a while.
We're working on it. We're working on it. Should I type something?
Yeah,
in?
I'm doing that.
Oh, you're doing it. Okay.
Can you hear us now? No.
Yesterday it worked. I don't know.
Of course it did. Type if she can check that her volume is on her computer. Check that her volume is on, because sometimes if she's, you know, at least I've done that sometimes.
Check 1 2 1 2. Check 1 2.
Yes, my volume, yes. But I can hear you, but it's
Very faint?
low volume.
So you can hear a little bit? No. Niente.
Can you hear this?
No.
I can hear just so distant noises. Try to speak, please.
Can you hear us?
Try to speak, please.
Can you hear us? Check.
Yes, okay, it's better.
So use this mic.
Okay. So,
Can you hear me?
yes, okay.
Okay, good. All right. Excellent. Okay, so it is my pleasure to introduce Kolis Samur, who is an associate professor of criminal law at the Free University of Bolenzano, Italy. Before joining the Free University of Bolenzano in 2009, she was a postdoctoral fellow and research assistant in criminal law at the University of Bologna School of Law. She received her law degree and her PhD in criminal law and criminal procedure at the University of Bologna. She was awarded, among others, research grants financed by the Max Planck Society. She has specialized in comparative legal research, and her research has focused on the general theory of criminal law. particularly causation and mens rea, as well as key topics such as gender violence and restorative justice. She has written 2 monographs, edited books, and authored more than 70 articles published in national and international journals and collections. She is a co-editor with our previous speaker of the book Criminalizing Intimate Images, A Comparative Perspective, which I've had the pleasure of reading. I'm repeating now this for her benefit, and am finalizing my review of the book. So I will turn it over to you. Thank you so much. Buonasera.
Yes, first of all, thank you for inviting me. Thank you to Professor Vitiello and his colleagues for giving me this great opportunity to be here. Even it's only online, and I'm very sorry that I can't be there with you, with my colleagues and friends, Matteo and Gianmarco. But okay, it's great to be here online, and especially I think it's important that we can discuss together about so important issues in a context of comparison. As Professor Wincliffe already talked us about the importance of comparing different legal systems stemming from different cultures, and we know that in Italy, Gianmarco just said it, the public prosecutor is required to prosecute crimes, and the victim has the right to participate in the criminal trial as a civil party. That's a big difference. That's the framework, and we are moving in there. So I'm sharing now my presentation. Can you see it?
Yes.
So my presentation today concerns the evolution of victims' rights through the lens of restorative justice. In the first part, I will briefly outline the development of the normative framework of the restorative justice in the European context, and present the different models and strategies adopted across Europe. Restorative justice, of course, plays an important role in helping to empower victims and in providing a safe environment to make their voice heard and to support their healing process. In European context, restorative justice is recognized by now as a valuable complement to traditional justice systems, and is increasingly being integrated into criminal justice administration. In the second part, I'm going to address the critiques and challenges related to victim-centered approach in Europe, and trying to highlight the importance of balancing victims' rights with the fundamental principle of criminal law. Like the victim rights movement, the restorative justice movement is experiencing criticism and skepticism, and actually restorative justice, I think, cannot be shaped solely for the benefit of the victims. It must be understood as a broader and transformative approach that engages all parties involved. And that will bring me then to the core of my presentation, that is the interaction between restorative justice and the criminal justice system. And here I would like to show that restorative justice services, programs, tools are already integrated into our systems, even though they are not always labeled as restorative justice, and that they are in this perspective, they serve multiple purposes. And that raises the fundamental question whether restorative justice is necessarily a victim-oriented and consensual justice paradigm based on the encounter between victim and offender, or it is something else. In other words, what makes justice restorative? And my conclusion is that the restorative justice could be a promising model in our systems, engaging and supporting victims while also addressing offenders' needs for rehabilitation and dealing with broader social issues. And so exploring restorative justice urges us to think and rethink the concept of punishment, considering more constructive and less punitive responses to crime, beyond victims and beyond the victims' rights perspective. But now I would like to start defining restorative justice. Restorative justice, and you can see here the common used, widely adopted definition of restorative justice in the European context, means any process whereby the victim and the offender are enabled, if they freely consent, to participate actively in the resolution of matters arising from the criminal offense through the help of an impartial third party, the mediator or facilitator. And this definition is provided by the directive of 2012 of the European Parliament establishing minimum standards on rights, support and protection of victims. Marco Carletti already talked to us about that. And similar formulations are adopted by the Council of Europe in the recommendations of the Committee of Ministers, Recommendation 2023 and Recommendation 2018. The same wide definition is also adopted by the Italian legislative decree of 2022, which for the first time introduced a very comprehensive and integrated discipline of restorative justice in Italy. The Italian law defines especially the restorative outcome as any agreement resulting from the restorative justice program aimed at repairing of the harm and suitable to represent the mutual recognition and the possibility of rebuilding the relationship between the participants. In conclusion, restorative justice is considered a flexible, responsive, and participatory and problem-solving process. Now, let's take a closer look to the aims and goals of restorative justice. Restorative justice, as suggested by its label, seeks to restore or repair damage caused by the offender's conduct. That means bringing together victims, offenders, and sometimes community members to collectively address the harm caused by a crime. In contrast to traditional justice models, which primarily focus on punishment and retribution, restorative justice centers on addressing harm, fostering dialogue, communication, and promoting accountability. And so we have two benefits. On the one side, offenders are encouraged to take responsibility for their actions, understand the consequences of their behavior, and take active steps to make amends. Victims, on the other hand, have the opportunity to express their feelings, have their voice heard, and regain a sense of control. As stated in the directive of 2012, restorative justice services are seen as tools of great benefit to the victim, and the concern is to prevent secondary and repeat victimization, intimidation, and retaliation of the victim. The recommendation of 2018 highlights other many benefits of restorative justice. Among others, the aim of avoiding marginalization and stigmatization of individuals, the objective of providing a path for meaningful engagement of the community, avoid recidivism and social alienation, and so on. To conclude, restorative justice aims to improve our justice system by an inclusionary and participatory approach, by valorizing the role of the victim and the offender. In short, it's a strategy to prevent crime and further future harm. So now let's briefly examine tools and instruments used by restorative justice for achieving its goals. It is well known that the term restorative justice covers several procedures, among others, victim-offender mediation, family group conferencing, sentencing, circles, reparation, restoration, compensation, warnings, community service, and so on. The term restorative justice is therefore not really a synonym of penal mediation, even though penal mediation is the most widely used method of restorative justice in Europe, at least. We should also consider that many interventions do not involve dialogue and communication between victim and offender, and implies innovative approaches to restitution, victim recovery, and offender reintegration. For example, reparation boards, witness support schemes, victim support circles, therapeutic communities, prisoner education, problem-solving courts, and so on. The recommendation of 2018 provides a list of this type of interventions and programs. And it is clear the goal of restorative justice goes well beyond purely financial compensation and beyond purely mediation between victim and offender. So that means that restorative justice at the end has different purposes: restitution, victim recovery, and offender reintegration and rehabilitation. So what was the development? How did restorative justice develop in the last decades? We know restorative justice has gained increasing prominence in the international debate, along with the rediscovery of the victim in the criminal justice process. And restorative justice initially emerged under the banner, let's say so, of a communitarian ideology. And it was conceived as a very radical alternative to traditional punitive justice. Over time, however, restorative justice has evolved to serve diverse purposes and policies. It ranges from a left-oriented, critical and progressive approach, aimed at challenging our punitive justice, to a neoliberal, efficiency-driven strategy intended to ease the burden of our judicial systems. The new paradigm of restorative justice today has been driven by two factors, basically. On the one hand, the aim to enhance the role of the victim in the criminal justice process. On the other hand, the growing disillusionment with traditional retributive and rehabilitative models of justice. And so we can say that the rise of the restorative justice represents the culmination, a result of broader social and cultural transformations, including the crisis of carceral sanctions and punitive justice as a whole, as well as a result of the evolving role of the welfare system in addressing crime. And over the year, the movement, the restorative justice movement, has gained strength from several other sources, like concern about recidivism, concerns about overcriminalization and overcarceration, over-imprisonment and overcrowding, the cost of penalties and the ineffectiveness of penalties. That it is precisely because of this complex and multidimensional nature of the restorative justice that this issue is particularly challenging And the phenomenon restorative justice is really hard to define. So, is there a restorative justice movement? The multidimensional nature of restorative justice entails a conceptual ambiguity. That means we can see two conflicting aspects, profiles of restorative justice. The tension is between a so-called holistic approach and a pragmatic vision of restorative justice. For some, restorative justice introduces a new system and independent system that will replace the traditional one. For others, restorative justice is a complementary model that must be integrated, implemented within the current one, the current criminal justice system. And therefore, the restorative justice movement itself exhibits a significant internal diversity owing to different approaches and different perspectives, and approaches by different stakeholders as well, like practitioners, researchers, policymakers, and interest groups. It is clear that restorative justice assumes a political dimension, and this point requires us to examine the process of the institutionalization of restorative justice and the development of the normative framework of in Europe of restorative justice in Europe. But you can see that's a list of the main documents, decisions, and legislation about restorative justice. And you can see the prominent role of the United Nations, and then later, at a later point, in a second phase, the interventions of the European Union and the Council of Europe. What's the European approach to restorative justice then? In the absence of a suitable legal basis, the European Union has not been able to adopt a comprehensive legislation explicitly dedicated to restorative justice, and restorative justice is included in victim protection legislation, the directive of 2012 mentioned already by Gianmarco. European legislation on victim protection clearly reflects a victim-centered approach in Europe, with its main objective being to ensure that all victims of all crimes can fully rely on their rights, and states are called upon to expand resources and support to help victims and to improve opportunities for victims to obtain compensations from offenders. You can see there are many principles pointed out in the European Union Directive, and member states must respect these principles and implement the principles in their own national domestic legislation. But a brief overview. As observed earlier, the directive doesn't include an obligation for member states to promote mediation in criminal cases, and so a slow process of adapting national legal systems to European and supranational requirements has begun, and now almost every EU member state has adopted a legal basis for restorative justice. Thanks to Directive 2012, goals have been achieved in terms of passing new laws and improving existing ones. But differences can be seen primarily in the relationship between restorative justice programs and the criminal justice system. In the perspective adopted, offender-focused perspective, victim support perspective, or on the type of programs provided by the legislation, system-based or community-based, independent from the criminal justice system or external from the different and external ones. Also, the scope of restorative justice is different. Most member states make mediation and restorative measures available only for minor offences. In other countries, like Italy, the access is general, is open to all offences, with no regard to the seriousness of the offence. So we can see that the impact of restorative justice is very different in member states. The Italian experience shows could be considered a paradigmatic one, because it's showing perfectly how restorative justice can be a flexible and multifunctional tool. It was initially limited to minor offences and developed within the juvenile justice subsystem, and then with the last reform, it is now embedded in the procedural and the substantive law. There are restorative techniques combined with probation, with parole mechanism. Sometimes compensation and restoration are built as diversionary techniques, or have an impact on sentencing, or can modify the execution of penalties, and so work in the phase of custody. To sum up, it could be restorative justice could be a diversionary technique, or can be a mechanism for extinguishing the crime and closing the trial, for example. So we can conclude that the definition of restorative justice is highly problematic, especially the relationship between mediation and restoration. And that brings us to the fundamental question, what exactly makes justice restorative? Because a common misconception can be observed, the belief that crime always reflects an interpersonal conflict, and that restorative justice is always a form of consensual justice, but that's not always true, because indeed a crime does not always involve conflicts in a strict sense, particularly in cases where there are no victims. For example, in case of endangerment offences, or where victims are entirely interchangeable, such as in case of terrorism, hate crimes, or environmental crimes. And it's therefore not surprising that in some countries, like Italy, restorative justice can be implemented not only through mediation and voluntary agreements between the parties, but also between the offender and the so-called surrogate, or a specific, not specific victim. That means a person who has suffered a similar crime in a different context, in a different case. And so, if the absence of the victim's consent is not so important, it's not that what matters. What matters in this perspective is only the restorative outcome. But what is exactly restorative? What can we consider restorative? And what must restore? And who decides? And this brings us to the next point. does restorative justice serve the interest of victims, or does it have a broader scope? And now let's talk about some pitfalls, and then I conclude. Like the victim-centrism of the European Union law and criminal law more broadly, restorative justice has faced significant criticism in scholarship. The most relevant critique concerns the maximalist victim-centered approach. In fact, restorative justice entails two distinct and potentially conflicting aspects. One focused on solidarity and empathy, and the other one focused on social defense. And these both trends raise concerns. On the one hand, the first trend promotes the victim's active role in the criminal process, increasing the risk of privatization and moralization of justice. On the other hand, the second trend, by placing the victim at the center of public discourse, may lead to more realistic law and order policies and a more punitive approach, a more punitive society. And in the European Union, this is combining with the human rights approach. That means that the victims of crimes are considered having right to justice and right to punishment, to compensation. And the state have a duty to compensate the victim. We can see it clearly in the Victims' Rights Strategy 2020-2025 of the European Union. But my final remarks are dedicated to the challenges, the future challenges of restorative justice. Some critics argue that the moral relational approach of restorative justice is based on an unacceptable ethical monism that conflicts with the ideals of a liberal society and a pluralistic society. The feminist criticism towards the restorative justice idea. Some others perceive restorative justice as too soft and lenient, and others are pointing out that mediation is a sort of private market bargaining. There is a risk of privatizing criminal justice and negotiating penalties, allowing offenders to buy their way out of prison. So we can see that also restorative justice can have a retributive element, and the real challenge here is to define what is punishment, how we can rethink punishment in future society accordingly to restorative justice principles and ideas. And it is important that restorative justice can be seen as more than just a punitive restitution and compensation or a diversion of offenders away from criminal procedure. Restoration, reparation can be a component, a part of punitive response, but not in a retributive function, but especially in a reconciling and rehabilitative manner, I think. In conclusion, it seems possible to protect victims beyond retributive paradigm by seeking a new concept of punishment that involves offender rehabilitation. And so I think most important points I try to summarize here at the conclusion of my talk can lead us to some optimism and think of a more humane model of justice to be pursued. One model that considers both the offender and the victim as individuals and that promotes social integration and dialogue within the community. And that conceived the punishment as a constructive project aimed at fulfilling constitutional objectives of culpability, accountability, and reparation. Thank you.
Thank you. Questions?
Are there any questions?
Okay.
Colas, thank you. And you're staying up late there, I take it. So it's wonderful to see you. I have a couple of quick questions. Empirical data. Does it work in reducing recidivism? Does it work in healing victims? Can you hear me?
Yes.
Oh.
The question is if restorative justice works.
Are there data? In other words, are there data on reducing recidivism, and are there data on levels of repair for victims?
No, there are not so many data because generally, yes, in criminal justice system, we don't make so empirical study, and therefore we have not enough data. The European Forum for Restorative Justice writes regularly reports on the impact and outcomes of restorative justice program, and they are promising. But I don't know precise statistics because member states and nor the European Union are providing statistics for general context of Europe. As I know.
Well, and I'm wondering if that's because, as you said, there's sort of internal differences. So
yes, there are huge differences. Yes, yeah. There are very significant differences between countries. And as I've said earlier, the European Union don't provide an explicit discipline and legislation about restorative justice. The directive provides just a few principles, very general principles, and so each country can build its own restorative justice system and mechanism, and that is the reason why we can find restorative elements within different areas of criminal law and criminal procedure in the member states, and that's the reason why restorative justice is considered an instrument for concluding trials or a way to mitigate sentencing. Because each state has a different approach to restorative justice. And sometimes they don't use the term restorative justice for this kind of programs and services. And so it's very difficult to monitor this changing and multidimensional phenomenon.
We have another question.
I can't hear.
Can you use the microphone so the speaker can hear?
Yes.
I just wanted to address Professor Vitiello's last question, which was, did you have any evidence regarding the outcomes as far as recidivism rate, and what was the second part of your question?
Victim restoration.
Victim what?
Whether victims were restored.
Okay. Yeah, and my thought would be that it's sort of like comparing
the microphone
to me a qualitative dissertation with a quantitative, because I don't know how you could actually measure that. But I think it's very idealistic, but I think that was a really good question.
And he's not even a law student.
I mean, that's what, yeah.
I'm sorry, I couldn't hear the question, please. Can you repeat, please?
It wasn't quite a question. It was echoing the point that Professor Vitiello made.
So it was the similar question about empirical studies on this point.
Because it's comparing like empirical data with more of a theoretical.
Okay, as I've said, we don't have at the moment empirical data across Europe, also general data. We can rely on statistics and reports of the restorative justice services, but also restorative justice services are very different in European countries, because in some countries there are private associations, volunteers. In others, they are public offices, depending from tribunals or courts. In others, there are social service systems, and that's really complicates studying this phenomena from an empirical perspective. We have a very big literature and comprehensive literature and vast literature on restorative justice in Europe, and in many articles and essays and studies we can find data, but I would say that it's qualitative research, not quantitative research. So we can find reports on single cases or similar group of similar cases, but it's qualitative research, it's qualitative data and not a quantitative research.
Thank you so much. Thank you so much for your contributions. Excellent. Thank you. Okay. Go ahead. Yes. It's now my pleasure to introduce our final speaker for this afternoon. Matto Leonatadakis is a senior assistant professor in criminal law at the University of Bologna. He has taught several criminal law courses for about 10 years. Throughout that time, he has spent time at the Max Planck Institute for the Study of Crime, Security, and Law in Friedberg, Germany. And in the spring of 2019, he was a visiting scholar at the University of Pacific McGeorge School of Law. He has published 2 books, written numerous articles in leading law reviews, and edited book chapters. His scholarship focuses mainly on criminal culpability requirements and offenses against individuals. His first book deals with mixed forms of culpability, partly intentional and partly negligent, and his second book focuses on medical malpractice, arguing that criminal liability should depend on nothing less than gross negligence. So without further ado, please.
So, thank you, Professor Van Cleve, and good afternoon to all. First of all, I would like to warmly thank Professor Mike Vitiello for inviting me. I truly feel honored to take part in this symposium with such prominent scholars. Let me also thank Tae Kim and Cara Anderson for very successfully taking care of many details of this symposium. In my presentation, I'm going to address the approach of the constitutions of European countries to crime victims' rights. In particular, I will focus on a recent proposal to amend the Italian constitution, arguing that there is no shortage of criminal procedure rights in this specific case. And rather, what is lacking is a strong network of associations that support victims on a regular basis in order to help them more effectively overcome the implications of the crime. So, as Gianmarco Caletti explained, there is a strong and detailed European Union framework regulation on crime victims. Several member states have broadly implemented it, but there are no explicit provisions on crime victims' rights in the constitutions of the most populous European country, neither in Germany, nor in France, nor in Italy, nor in provisions having constitutional status in the UK. And why? This is because many European constitutions date back to the second half of the last century and had to overcome various non-democratic political experiences. Enhancing citizens' protection from state power was a priority at that time. Therefore, it seems quite normal that many European constitutions are inspired by the Enlightenment tradition, which focuses on the guarantees of the accused. There are, of course, some exceptions, are a few exceptions. For example, both the Portuguese and Swiss constitutions contain a provision on crime victims. Both are, as you can see, rather general provisions, but we can still see an important difference. In particular, while the Portuguese constitution establishes the right of victims to take part in criminal proceedings, the Swiss constitution focuses on aid measures that do not necessarily depend on a judicial process. Italy could be the first big European country to introduce an enshrinement of crime victims' rights in the Constitution. But how? The first draft of the Senate proposal was intended to introduce a general constitutional provision on criminal proceedings in order to rebalance the accused-centered approach, which is a result of a constitutional reform dating back to 1999. I'll come back to the shift from the first version to the second one of the proposal in a couple of minutes, after a brief overview of the similarities and peculiarities between the Italian debate and the American one. Among the similarities between the Italian debate and the American one, there is the equal rights claim. The equal rights claim, typical of the American Mercy's Law campaign, is the same one that inspired the first draft of the proposal to amend the Italian Constitution, which aimed to directly affect criminal proceedings. The main concern in Italy and as in the US, if I'm not wrong, is that there may be an alteration of the adversarial model affecting the rights of the defendant, which is traditionally considered the weaker party of proceedings. Roles are reversed compared to the time of the commission of the crime. That's why I do think that the equal rights claim does not totally get it right. One important difference is that the Italian proposal doesn't provide a set of rules or rights, but a general principle. And that's not necessarily reassuring, because it is less predictable exactly what implications a principle may have. There is a sort of fear of the unknown. On the home page of the California Victims Resource Center website, it is highlighted that Mercy's Law provides 17 enumerated rights for crime victims in the California Constitution. I do agree with Professor Cassell that we can positively deem at least a lot of them, but with regard to Italy, which already provides several procedural rights, The concern is where a totally general principle can lead, who knows? As a result of the hearing of experts with different opinions, of course, the second version of the Senate proposal renounces directly affecting the balance of criminal proceedings and no longer includes any reference to persons damaged by crime. What did the reference to persons damaged by crime raise concern? Let me give you a couple of examples. In the Morandi Bridge collapse case, more than 700 individuals and legal persons damaged asked to take part, a civil party claiming restitution, in the criminal trial against 59 defendants. In the Monte dei Paschi di Siena Bank case, around 5,000 civil parties with about 40 attorneys were against 3 defendants. This happens because in Italy, individuals and legal persons are entitled to be, quote, civil parties, unquote, of criminal proceedings with their own attorney, their own right to evidence, and they claim restitution, even if they have suffered only rather indirect damages. In situations such as those described in the PowerPoint, this proportion of the forces opposing the defendants is rather evident. Beyond the issues of balance in criminal proceedings, a strong concern is that victims' rights policies may result in increased criminal law, and we have to be aware that Italy has mandatory prosecution, as said before, and those policies may result also in harsher punishments. I'll give you an example. A symbol of the Italian victims' rights movement legislation is the so-called Code Red of 2019 on gender-based violence. It added new rules, victims' rights, on criminal procedure, but at the same time, it introduced a new offense or revenge porn, and that could be considered a good choice, but also established harsher punishments for the main crimes related to gender-based violence, domestic mistreatment, sexual violence, stalking, and this is a greater harshness without any valid ground. This is what I mean when I refer to the scale. The protection of some groups, such as crime victims, can correspondingly affect the position of other people. That is, the movement of one pan affects the other pan. Some other general concerns. The current prison overcrowding index is 133%. There are 62,000 inmates for 46,000 slots in Italian prison. In 2024, the yearly record of inmates' suicides was broken, 89 inmates, plus 7 prison officers. There have also been symbolic judicial choices in the 2 most media-attracting cases in recent years of women murdered by their partners. A conviction and a prosecutor's closing argument hearing were scheduled for November 25, which, as known, is the International Day for the Elimination of Violence Against Women. And I ask you, is that a coincidence? I'll let you answer that yourself. To give you another example of where an emotional pro-victims approach can lead, please look at this picture. I personally took this picture in Bologna, walking to the university a few weeks ago, and this writing appeared along with a transgender symbol right after the decision on the Pellicot case. It is the case of a French woman who was sexually abused on several occasions for 10 years by her husband and many other people after being each time purposely put into a state of unconsciousness. This woman actively faced the trial, symbolically keeping her husband's last name and setting herself as an example of strength and courage for other victims. The decision of conviction for all defendants was welcomed by the press throughout the Western world as a symbolic moment of justice and hope, although it was pointed out everywhere with a bit of dissatisfaction that only the husband was convicted to the maximum punishment possible, 20 years. To conclude, there is an abundance of victims' rights related to criminal procedure, but there is still a gap in Italy in out-of-court support services for economic reasons. There are commendable private associations, but they are ordinarily sector-specific, maybe two sector-specific. The majority of them is on gender-based violence or domestic violence, and a general network is lacking. They have limited economic resources. There should be a significant deployment of public funds, this is what I argue, in multidisciplinary victim support services, which work on a daily basis away from the antagonistic context of the trial and the media spotlight, exactly like restorative justice does, as Collie Summer said before. In this way, it would be more plausible to imagine effective protection for victims without necessarily at the same time striking a balance with the guarantees of the accused. Thank you.
Thank you. Yes, get in the mic.
Yes, thank you for a very interesting presentation. And if you could go back just one slide at the end, I want to hear more, because I see your last sentence is that it is plausible to imagine effective protection of victims. So I was wondering if you could expand on what that might look like. And of course, I will prod you in a particular direction, which is, wouldn't more effective protection be participatory rights for victims, which would avoid your concern about increasing the harshness of the system?
Thank you, Professor Cassel, for your excellent question. My stance is that there should be a kind of social service protecting victims. I don't think that it's just a matter of procedural rights. That's my point. And this is argued also by many prominent Italian scholars that says that a social service, kind of social service protecting victims should be a right solution, and in that way we will let victims not be trapped into an illusion, because of course are very important the procedural rights, because starting from the information to victims. But if we leave victims alone and we don't provide a daily basis support, maybe we don't really help them overcoming their painful condition. This is what I argue. Of course, it's a matter of investment, public funds deployment. And as Gianmarco said before, for a legislator, it's too easy to provide new crimes that cost nothing. And on the other end, providing effective social services could have some relevant costs. social services and participatory rights? Yes, we have many participatory rights in our system. They are provided by statutory law, yeah. And my concern is where a general principle can we lead? How can our constitutional court will manage with this principle? It may take actions in order to implement rights, but in what way? And this uncertainty raises some concerns to me.
So thank you. Very interesting, both paper and presentation. So I heard kind of your framework, and I want to ask kind of a background question, which is what was the articulated, or at least publicly articulated, reason for wanting to amend the Constitution in Italy in light of the fact that you've identified so many statutory procedural rights? And I'm curious in large part because domestically in the US, with regard to both at the state level and at the federal level, among the articulated reasons is that the statutes are not they're not effective, and that when in a hierarchy of law, they can be ignored in judicial decision making. And so that's been the impetus domestically for moving towards constitutional amendments. And so I'm just curious why?
Thank you, Professor Garvin. It's a very good question. I would not say that in Italy, procedural rights provided for victims are not taken into account seriously. Judges and prosecutors apply those provisions, but in our Constitution there is a list of rights for defendants that comes from a constitutional revision dated back to 1999. Since that time, a lot of crime victims advocates argue that there is need to change our Constitution in order to rebalance this defendant-centered approach. But there's not an issue of lacking of effectiveness in our courts. I would say that it's more like a trend. There is a lot of attention on crime victims' rights, and this period, this historical period, should be for supporters of crime victims a good moment in order to amend our Constitution. It's mostly a cultural attempt, I would say.
Can I just add one difference that struck me when I was looking at the Italian criminal system is, and I think this is still true, is that public prosecutors and judges are trained in the same way.
Yeah.
Yes, so public prosecutors are essentially judges.
Yeah.
And I was watching criminal trial one of the first times that I went to Italy to observe, and somebody who had been the public prosecutor on Friday, and maybe I exaggerate a little bit, was on the bench on Monday. And so it, as compared to our prosecutors, it's a different mentality if you're trained as a judge rather than elected and focused on your win-loss record. Again, as compared to. So that might add to that.
Professor Van Cleef, you're right. We have to consider that in Italy, judges and prosecutors come from the same competition. They are both public
magistrates.
Magistrates, and This affects the adversarial model because the prosecutor is considered more reliable than the defense attorney. We have
Defense
to consider
attorneys
some
have
factors.
been arguing
There
for
are many
years
factors.
for a separation.
Yeah. It's under exam of the Italian Parliament now, a reform in order to totally separate the career of prosecutors from the one that regards the judges.
Interesting. Although one case that I observed, the public prosecutor got up, this defendant had different defense attorneys throughout the proceedings, and the public prosecutor got up and said, at the very beginning, this defendant's attorney should have requested one of the abbreviated proceedings, I forget which one, which would have entitled the defendant to a reduction in sentence by statute. And so the prosecutor was saying, since his attorney did not request that, I think that would be fair to give him the benefit of that reduction. So there's more of a sense as compared to our prosecutors, and maybe not, all the time in Italy, but more of a sense of getting the right result than necessarily getting the win, as compared. Yeah.
As Professor Vitiello said before, I have nothing against victims, of course. What I try to do is to let you know some concerns of Italian scholars and why these concerns are plausible, at least in a justice system such the Italian one.
Yeah.
You seem to be skeptical of the Italian Supreme Court's ability to get the right result, and here in America, everybody has 100% confidence in our Supreme Court to achieve the right result.
Thank you.
Thank you very much. Thank you.
Thank you so much, everyone, for coming. My name is Kara Anderson. I'm the editor-in-chief of our Law Review, which is the sponsor of this event in partnership with the Victims Resource Center here on campus. So I just want to say thank you again to all of you for joining us, for your engagement and your questions. It's been wonderful learning with all of you because I know very little about criminal law. So thank you so much to our panelists for their presentations, for traveling, some of you great distances. We really appreciate you joining us and your contributions and your papers, which we're very excited to publish. Thank you to the Law Review Board for their wonderful work. Tay Kim, who is hiding back there, is the symposium editor, and she has handled this so graciously and efficiently. So thank you so much for that. Thank you to the rest of our Law Review Board and even some non-Law Review students who just lended a hand and came in when we needed them. So thank you all so much. We have, as you see in your program, the 40th anniversary reception for the California Victims Resource Center happening around 3:30, but we can start heading over there. It's in the Grand Salon, and if you don't know where that is, you'll go out these doors across the street into the main campus quad area of the McGeorge campus, and it's inside of our law library, which you'll go straight and turn left. If you don't see it, there'll be a group of us going over there, so you're welcome to walk with me. And that event will have refreshments and some remarks from the Victims Resource Center leadership if you'd like to learn more about what they're doing now and what they've accomplished over the last 40 years. So thank you all again so much, and I wish you a wonderful rest of your day.